Colleagues could be seated. The clerk will now proceed to read the orders of the day.
Victims and Courts Bill, second reading.
Now, Minister to move, second reading, and I call Shabana Mahmood. Minister.
Thank you very much, Madam Deputy Speaker. I beg to move that the bill be read a second time. Madam Deputy Speaker, when this government took office just 10 months ago, we inherited a justice system in crisis. Our prisons were on the point of collapse, the backlog in our courts was at record levels and rising fast, and victims were all too often paying the price. Madam Deputy Speaker, this government is beginning the long and hard work of rebuilding our justice system so it serves victims once more. In my eyes, that means meeting three principles. The first is that justice must be swift. It is all too easily said that justice delayed means justice denied, but few have had the bravery to wrestle with the implications of that. This government is investing more in court sitting days than any before it, but we know that is not enough. So this government will pursue reform, even if it courts opposition, in the pursuit of swifter justice for victims. And that is why I have asked Sir Brian Leveson to propose once-in-a-generation reform of our courts. Jury trials will always be a cornerstone of our legal system for the most serious cases. But it is clear we must consider whether there are cases heard before a jury today that could be heard in a different way, in front of magistrates or a new intermediate court, in order to deliver the swifter justice that victims deserve. The second principle of a justice system that serves victims is that punishment must be certain. This government inherited the grotesque position where we had more prisoners than prison cells. If prisons run out of space, it is victims who pay the price. If courts halt trials and the police are forced to stop making arrests, crime goes unpunished and victims see no justice done. This government will ensure that criminals face punishment. We are building 14,000 prison places, the largest expansion since the Victorian era, after 14 years in which the Conservatives added just 500 cells to our prison estate. And we are reforming sentencing so that our prisons never run out of space again, and there is always space inside for dangerous offenders. The third and final principle of a justice system that serves victims is that they are not re-traumatised by their engagement with it. That third principle is what unites the specific measures set out in this bill. I would like to start with measures to force criminals to attend their sentencing in court. In recent years, too many offenders have been allowed to cower in the cells rather than face the consequences of their actions. This is a final insult to victims and their families because it robs them of the chance to tell offenders through victim impact statements the pain they have caused. It robs them of the opportunity to look the offender in the eye and see them face the consequences of their crime and face the full reality of their punishment. This bill will change that. It gives judges the power to order criminals to attend sentencing hearings. It makes it clear that reasonable force can be used to ensure that that happens. And it hands out punishments to those who still defy that order. Adult offenders could face up to an additional 2 years in prison and an unlimited fine. But I know that for those offenders who are serving long sentences or perhaps whole life orders, this is little punishment because they did not expect to see the light of day at all. For that reason, we will also give judges the power to impose prison sanctions on offenders. And this includes confining criminals to their cells, loss of privileges, and we will go further, including limits on social visits. If offenders do appear in the dock but behave in a disruptive or disrespectful way, as has all too often been the case in recent months, judges must have the ability to remove them from the courtroom so that the hearing can continue and justice can be served. This law will give a judge the ability to impose the same penalties applied both to those who refuse to attend their sentencing and those who attend but attempt to disrupt proceedings. Whilst the previous government brought forward similar measures, we are going further by expanding the range of punishment available through amending prison rules, which will expand the sanctions available to judges, and we will extend the length of time these sanctions can be applied. I will give way.
I'm grateful to my right honourable friend because I really do welcome this section of the bill, because my constituent Sabina Nessa was brutally murdered when she was on her way out to meet a friend, and her murderer refused to attend court and participate in his sentencing, and this actually caused a great deal of distress to her family. So I really welcome not just the move to force these characters to turn up in court, but also to apply sanctions when they don't comply. And I think my right honourable friend is to be congratulated on this.
Chancellor.
Well, I thank my honourable friend for his intervention. He speaks of one of the tragic cases that has led to these changes in the law, and that, in fairness, the previous government was also seeking to act on before the election is called, and that we are pleased to be able to go further in terms of the sanctions that have been available. I know some of the families are here today, and I will come to paying tribute to them in a few moments as I make further progress in my speech. Madam Deputy Speaker, we will be taking a delegated power to allow the Secretary of State to specify sanctions in regulations. These regulations will provide discretion to prison governors who hold a legal responsibility and accountability for what happens inside prisons. And judges will retain discretion over when to order offenders to attend. This means that in cases where a victim's family does not want to see the offender forced to attend, judges can decide differently. As this is a delegated power, the list of sanctions is not presented on the face of the bill that we are debating today, but will be rooted in the Prison Rules 1999, which will be amended and extended. The Secretary of State will have the ability to add more sanctions in future, quickly and easily, should that be necessary. And this approach, we believe, offers much more flexibility than a rigid list which would require the lengthy process of primary legislation to amend. Madam Deputy Speaker, I know that for many, this day has been a long time coming. I'm sure the House will therefore join me in paying tribute to the families of Olivia Pratt-Corbell, Jan Mustafa, Zara Elena and Sabina Nessa. And I would like to welcome Cheryl Corbell, Antonia Elvison, Jabina Islam, Aisha Hussain and her daughter Angel, who are in the public gallery today. They have suffered unimaginable pain and then face the indescribable trauma of an offender who would not face them. They have fought tirelessly to bring about this law, and we owe them a debt of thanks for their courage and their fortitude. Today is their day, and it will have a lasting impact for others yet to come, who should never have to face what they have endured. While nothing will ever lessen the pain of such immense loss suffered by these families, this measure in this bill is brought forward in the name and memories of Olivia, Zara, Sabina and Jan. Madam Deputy Speaker, this bill will also address the trauma that reverberates years after a parent has sexually abused their child. Today, a parent convicted of sexually abusing their child can continue to exercise parental responsibility for them. From behind bars, these vile abusers have been able to continue interfering in the lives of their children. Today, a mother has to request that parental responsibility is restricted in the case where a father has committed a sexual offence against their child. Now, we will automatically restrict the exercise of parental responsibility by anyone sentenced to 4 years or more for serious child sexual abuse against their children. It will restrict those rights from the moment of sentencing, so children are immediately protected. It sends a clear message that abusers no longer have the power to exercise control, and it will spare families the trauma of having to go through proceedings in the family courts by making this automatic, giving them the space they need to begin healing and to move on with their lives. The previous government brought forward proposals in the Criminal Justice Bill to apply this measure to offences committed against all children, but that measure was restricted to child rape. Under their proposals, a parent could commit a wide range of heinous sexual offences against their child, including sexual assault and sexual exploitation, and not be covered. We believe this was clearly too narrowly drawn because it overlooks the devastating impact of a parent committing other serious sexual offences against their own child. So whilst we supported those measures while in opposition, we are now strengthening them in government. Our measure will cover all serious sexual offences committed by a parent against a child they have parental responsibility for, such as sexual assault and sexual exploitation, causing a child to watch a sexual act, and sexual activity without consent. There is no denying we are in novel territory with this measure, and as such we have a duty to take a balanced approach. This automatic restriction can and likely will be challenged. We do not yet know how many challenges the courts will receive. We have a responsibility to ensure that the courts are not overwhelmed and that vulnerable children also going through the family court do not suffer. For that reason, we have chosen to expand the offences beyond child rape, but begin by restricting our measures to serious sexual offences where a perpetrator holds parental responsibility for their victim. I have heard the strength of feeling from survivors and campaigners who want to see our measure extend to all offences against any child, not just where a perpetrator has parental responsibility. I understand the calls on us to be as ambitious as possible and to expand this to a wider cohort of offenders. But we believe our measure is stronger than what came before, and it is the right starting point for this novel change. We will work collaboratively and constructively with members across this House and with those within the sector. And I do say to them all, this is the beginning of legal change in this area and not the end. Madam Deputy Speaker, this bill will also strengthen the power of the Victims Commissioner so that victims aren't forced to fight every fight themselves, but have the strength of the Commissioner, both the individual and the office, to fight for them. This will mean there is proper accountability when victims are let down by the justice system, and it will ensure that victims aren't traumatised by having to fight for every improvement to the system.
I'm really grateful to my right honourable friend who's making an excellent presentation to the House right now. My constituent, Kevin Curran, has campaigned all his life in memory of his brother Declan, who tragically took his life. He was a victim of child sexual abuse. And being able to access therapeutic services is one thing, but we know that many therapeutic services are very reluctant to provide that service for the sake that their evidence from their medical records could well be used to try and break a case. Will she ensure that people will not only be able to get access to those therapeutic services, but their records will not be used in evidence to destroy a case?
Lord Chancellor.
My honourable friend raises a really, really important point, and I'm sorry about the case of her constituent. She'll know that is one of the leading recommendations from the ICSA review. It's something that the Department of Health has already committed to taking forward, and I know that we will see more progress made in this area. Madam Deputy Speaker, under this bill, for the first time, the Commissioner, the Victims Commissioner, will be able to act on individual cases that expose systemic failure. On this basis, they will have the power to request information from agencies on why a failing has happened, what will be done to address it, and how we can drive change across the system. I will.
To the Lord Chancellor for giving way. I welcome the inclusion of this measure in the bill. And does she agree with me that the extension of this measure to local authorities and social housing providers is essential if the Victims Commissioner is able to fully represent victims of antisocial behaviour?
Lord Chancellor.
The Honourable Member makes a really, really powerful point, and I'll just come a little later into my speech why we as a government and why I reject the idea of antisocial behaviour as if it's somehow low level and therefore outside the purview of the Victims Commissioner and their powers, and that is why we are extending them. And I hope that I welcome the support that this has received from him and from others across this House. I hope this is something that we can all work on collaboratively together to ensure this measure can take proper effect. Madam Deputy Speaker, the bill will also require the Commissioner to produce a new independent assessment each year, providing much-needed scrutiny over how public agencies are meeting their duties under the Victims' Code. It will ensure victims' rights are being upheld, and where they are not, that action is being taken. And this bill will also... I'll give way.
Can I thank the Minister very much for bringing this forward, and what the Honourable Lady is outlining is exactly what we would like to hear. One of my constituents has asked me this question. I want to repeat it if I can for the record. In the restoration of justice, the victim often feels isolated from the process. So does the Minister believe that for this bill to be effective, communication is the key? And does she also believe that this bill goes far enough in providing that obligation for communication? I know the Honourable Lady wants to see that, but just to satisfy the conscience and the inquiries of my constituent, please. Thank you.
He makes an important point about communication with victims, and I will come a little later in my speech to the specific measures in this area that we think will enhance the system we currently have and provide a good foundation for us to continue to build on, so that victims have the information they need, both to get through the process of the criminal justice system, but also to keep them updated once an offender has served their sentence and is on licence in the community. Madam Deputy Speaker, this bill will also bring greater accountability to... just once more. It's very hard to say no to the honourable gentleman.
I meant to just ask to ensure that the legislation put forward today also applies to Northern Ireland. I understand that it does, but just maybe the Honourable Lady, again, I should have asked that question. Apologies for not doing it before.
These matters are devolved in Northern Ireland, so the bill that we are bringing forward today applies in England and in Wales, but we are in regular contact with our counterparts in Northern Ireland, and I know the Victims Minister will engage with counterparts to make sure that where possible arrangements reflect each other. I think we all have an interest in making sure the system across the whole of the UK is as strong as it can be. Madam Deputy Speaker, this bill will also bring greater accountability to how agencies respond to victims of antisocial behaviour. As the House will know, this is an area where many victims are not heard and not supported, with incidents too often dismissed as minor or low-level crimes, when in reality this behaviour has a devastating effect on local communities and on people's lives. This bill will therefore empower the Victims Commissioner to request information from local authorities and social housing providers who sit outside of the criminal justice system to better understand how victims of antisocial behaviour are being supported. These measures are an important first step towards rebuilding victims' confidence in the system, ensuring their voices are heard and leaving public bodies in no doubt that they will be held to account when they fall short. I give way to my honourable friend.
Thank you, Madam Deputy Speaker. I'm very grateful to my honourable friend for giving way. She's making an excellent speech, I believe, some very compelling points. And on this particular aspect of her speech, I would like to warmly welcome it and say how closely it resonates with the feelings of many of my constituents in Reading Town Centre and other parts of Reading who've suffered, unfortunately, from antisocial behaviour in many different forms. And I'm sure other colleagues around the country experience exactly the same, and I do commend her approach and thank her for her work.
Lord thank my honourable friend for that intervention, I know already that this part of the bill will get lots of support from across the House, and I think it's important that we send a clear message that in strengthening the Victims Commissioner's powers so that they can take more action on antisocial behaviour, that we will not tolerate antisocial behaviour ruining the lives of our constituents up and down the country. I'll give way.
I thank her for giving way. Antisocial behaviour is a huge issue in my constituency of Clwyd East. I have seen the impact it's had on many of my constituents, blighting our communities but also making people fearful in their own homes. I felt a real disappointment from my constituents as this has been termed as low-level crime, and that has sort of impacted the support they felt they've got. Does she agree with me that we absolutely need to ensure that it's not dismissed as low-level crime and that we see the victims of antisocial behaviour put at the forefront of our justice system?
Lord Chancellor.
My honourable friend is an assiduous champion for the people of Clwyd East, and let me assure her I approach this as a constituency MP as much as I do a cabinet minister, and like her I have had far too many of my constituents suffering antisocial behaviour, unable to move on in their lives because of the trauma that they suffer day in, day out, and then to feel like nobody takes it seriously. And in this bill, the Victims Commissioner will be able to hold local authorities and social housing providers to account to make sure that they deliver for the victims of antisocial behaviour. Madam Deputy Speaker, let me move on to other measures in this bill relating to the Victim Contact Scheme. The Victim Contact Scheme plays a critical role in communicating information to those who are eligible to receive it. The legislation governing it is now over 20 years old, and we know that there are issues with the scope and operation of the scheme. Victims repeatedly express that the criminal justice system is too complex, disjointed and difficult to navigate, including when trying to access support. Where we can simplify and rationalise the system, we should. That is why, Madam Deputy Speaker, this bill will streamline the system. It will bring victims currently served by different operational schemes into the Victim Contact Scheme, as well as providing all victims with one clear route to request information through a new dedicated helpline. Taken together, these measures will better support victims and ensure they receive the right information about offenders at the right time. Next, Madam Deputy Speaker, I will move to measures that will improve efficiency, delivering swifter justice for the victims of crime. Timely access to justice is a cornerstone of public confidence in our legal system, yet we face a shortage of prosecutors, an issue that directly contributes to delays in our courts. At present, legislation prevents the appointment of qualified legal professionals, such as Silex practitioners, as Crown prosecutors, even when those individuals are eminently capable, have experience in criminal litigation and hold the necessary rights of audience. I will give way.
Grateful for my right honourable friend from giving way. Only at the weekend I was discussing with a district Crown prosecutor and another Crown prosecutor the backlog that we have in our court system, and there was a strong expression of concern that there is a recruitment and retention problem within the CPS, and so I welcome this new measure, which I think will go a long way in ensuring that we do have enough Crown prosecutors so that the system, the backlog that we have in the court system will be eased.
Chancellor.
I thank my honourable friend, and we hope that this bill and the measures in this bill will provide some immediate relief on the recruitment of prosecutors, because this bill addresses an outdated constraint. It will remove these unnecessary legislative barriers and allow the CPS to recruit Crown prosecutors from a broader, more diverse pool of talent. Estimates suggest that there may be more than 800 Silex specialist criminal practitioners who have expressed an interest in becoming a Crown prosecutor. It will support greater flexibility in resourcing and may help to shorten waiting times for cases to be prosecuted. Madam Deputy Speaker, this measure supports our manifesto pledge to ensure more prosecutors are available and, above all, may in future help to reduce the long, painful wait that many victims face for their case to come to court. Next, Madam Deputy Speaker, we are committed to reforming the private prosecution system so that it is fairer and has the right safeguards in place. In this bill, we are taking the first steps towards longer-term change. Although private prosecutions play an important role in our justice system, the way private prosecutors' costs are awarded can provide perverse incentives for firms to bring private prosecutions. Costs in private prosecutions can be over 5 times higher than in cases where both defence and prosecution are funded via fees, which are set out in regulations. That is why, Madam Deputy Speaker, this bill will give the Lord Chancellor the power to make regulations to set rates at which prosecutors can recover their costs from central funds in private prosecutions. This will ensure the best use of public funds and reduce the incentive for private prosecutors to prioritise profit when considering bringing criminal proceedings. I'll give way.
I'm just about to mention that this comes from a proposal by the Justice Select Committee, but as long ago as 2020, under my distinguished predecessor, Sir Bob Neal, KC, and I'm glad to see that it's finally reaching the statute books.
Chancellor. I was just coming to paying tribute to the work of the Justice Select Committee, to Sir Bob Neal and to our current esteemed chair of that committee, and I thank him and members both past and present for pushing for government action on this matter, and I'm glad that we've been able to bring forward the measure in the bill that we have today. Madam Deputy Speaker, let me now turn to measures on the unduly lenient sentence scheme. As the House will know, this safeguard allows the Attorney-General to refer certain cases to the Court of Appeal. This action is taken if it is believed that the original sentence does not adequately reflect the seriousness of the offence. However, in practice, the 28-day statutory time limit for referral has proved problematic for cases brought to the Attorney-General's attention late in that 28-day period. This bill will ensure that every eligible case is properly scrutinised, guaranteeing that the Attorney-General has 14 full days to assess any request when it is received in the final fortnight of that 28-day window. This change will ensure that enough time is allowed for cases to be fully considered and referred to the Court of Appeal as necessary, and therefore provide greater clarity to victims, families and the public. Finally, Madam Deputy Speaker, this bill will create greater consistency in the courts through a targeted and technical amendment to Magistrates' Court sentencing powers for 6 specific offences. In this, we are tidying up an anomaly that we inherited. These 6 offences were not included during legislative changes made by the previous government, and by ensuring everything is aligned, this change will ultimately help to avoid confusion and errors in sentencing. Madam Deputy Speaker, this bill marks an important step forward in our mission to rebuild our justice system, so that it serves the victims who, in recent years, it has all too often failed. It brings forward long overdue reforms that will strengthen victims' rights, forcing offenders to attend their sentencing hearings, restricting the parental responsibility of convicted child sex offenders, and further empowering the Victims Commissioner. The criminal justice system in this country suffered terribly at the hands of the party opposite. The backlog in our courts is long and growing longer. Our prisons are trapped in a cycle of crisis, and victims have paid the price. This government is beginning the work of reversing that damage. We will deliver swifter justice for victims, we will ensure that criminals face certain punishment, and we will ensure our justice system serves victims rather than subjects them to trauma on top of what they have already suffered. This is just the beginning, I know. There is much more that we must do, Madam Deputy Speaker, but the work is underway, and I look forward to a constructive debate ahead, and I commend this bill to the House.
The question is that the bill be now read a second time, and I call the Shadow Minister, Robert Jenrick.
Thank you, Madam Deputy Speaker. In recent months, I've sat with Jeremy and Susan Everard, whose daughter Sarah was murdered in the most horrific circumstances, with Paula Hudgell, whose little boy Tony lost both legs to brutality and who asks why his abusers will one day walk free, with Katie Brett, whose sister Sasha was stabbed to death at 16, and with Aisha Hussain, cousin of Jan Mustafa, whose body was found in a freezer with a catalogue of official failures. Their stories are harrowing, and their bravery and resilience is incredibly inspiring. They and the relatives of countless other victims have formed the Justice for Victims campaign group because, in their words, serious criminals are escaping proper punishment. Their demand is clear: make the system value the lives of those that were damaged or even taken. And we welcome legislation in the name of victims. It must be worthy of that title. A bill that carries the word victims should put victims first in practice and not just in prose. I appreciate, as the Secretary of State has rightly said today, that there are some measures in this bill that are stronger than those in its predecessor. There are some less so, or at least different to what were in the prior bill. Parliamentary time is precious, I know from my own period in government that one cannot always return to the same issues time and again, however worthy the topic. So we mustn't waste the opportunity afforded by this bill to enact the most radical and serious changes that we can to rebalance the criminal justice system in the favour of victims. Let me explain why and make what I hope will be seen as constructive proposals to the Secretary of State. Firstly, victims rightly want offenders to face them at sentence and to confront their crimes. All too often, cowardly criminals squirm away from the consequences of their actions. So I welcome the intent behind Clause 1, which proposes to correct that. I do question how the Minister will deliver recalcitrant offenders to prison when our own prison officers are already fighting for their lives with bare hands and little serious protection. That's not a new problem, but it's one that we all have to confront together. With no kit, there can be no confidence. In the wake of the HMP Frankland attack, the Minister's idea of a limited taser trial sometime this summer in a handful of prisons for specifically trained staff only seems inadequate. We still don't issue every single officer with a stab-proof vest. Body armour is under review. Clause 1, for understandable and right reasons, piles fresh duties on staff who tell me that they're already one assault away from leaving the service. Until ministers fully issue full body armour and staff our escort units properly, this duty will be a burden to them. We know this because officers will not feel safe to force violent offenders out of their cells, not least because the bill only affords them the use of reasonable force, not the ability to use force as long as it is not grossly disproportionate. Surely that should be the threshold in law. And judges making these orders only need to take into account information only need to take into account in consideration the reasonable excuse of an offender to override the concern and the will of victims. What is the reasonable excuse to dodge justice? Surely this should be tightened to the most exceptional circumstances. Where in this bill is the right of victims' views to be heard and recorded in court? Some victims will want the offender to come before the court, even in the knowledge that it will be highly disruptive, that it will challenge the solemnity of the court, and frankly behave in a way that many would consider to be deeply shocking and even scarring. Surely that should be broadly their choice, or at least that they should be properly consulted by the judge. This legislation is ultimately for the victims, even if the judge might have reservations, or this leads to challenging situations, confrontations that we are not accustomed to in our courts.
Would my right honourable friend
happily give way?
Does my right honourable friend agree with me that using the test of reasonable force, as the Lord Chancellor proposes, raises the unpleasant prospect that prisoners so forced might then bring claims for damages against the Lord Chancellor, which would be a further insult to victims, and I would firmly support his view that grossly disproportionate is the correct legal test to use.
Well, I thank my honourable friend and agree with the point that he's made. Given that the threshold of grossly disproportionate is an available and established concept at law, why not apply it in these circumstances so that we can equip the criminal justice system with the standard that they need to ensure that all bar the most exceptional circumstances, these individuals are brought to court, if that is the wish of the victims of crime. Secondly, Madam Deputy Speaker, ministers say that Clause 3 protects children from predatory parents, but the devil is in the detail. Only abuse of an offender's own child counts, a point understandably made by the party opposite when they were in opposition themselves. If a man rapes a neighbour's child, he keeps full rights over his own infant daughter. The BBC this morning highlighted the case of Bethan, forced to spend £30,000 in the family court to strip her ex-husband, jailed for the gravest of offences, of parental responsibility. Bethan's family call the bill very disappointing because it would not protect them. Additionally, offenders jailed for 3 years and 11 months, still a grave sentence, retain their rights. Where is the logic behind 4 years? This, thus far, is unexplained. Where is the child's best interest? Conversely, the bill states the order does not cease to have effect if the offender is acquitted on appeal. So an exonerated parent may still be barred for life unless they marshal funds to return to court. That is neither proportionate nor principled. I appreciate the Secretary of State's view that this may well be a starting point. But let's get this clause right. This is the opportunity. It may well be the only opportunity for some time. Now, turning to Clause 11, the unduly lenient sentence scheme is victims' last safety valve when a judge gets it badly wrong. I know how important this is. Just last week, a case I referred to the Attorney General, alongside the member for Keighley, was heard in the Court of Appeal, and 3 defendants had their sentences increased. But today a victim only has 28 days from the date of sentence to request the Attorney General make a referral. That clock starts even while they are still waiting for the official transcript to land. Everyone in this House has met families who discover the scheme after the deadline, who will forever wonder whether justice slipped through their fingers because they should have Google searched the rules a week too late, or reached out to their lawyers or to friends more knowledgeable in the system. And I've been very struck recently, speaking to victims, even victims of some of the most prominent and heinous crimes of modern times, who one might have thought would have been equipped with the very best legal advice and support, who simply didn't know this scheme even existed, let alone that it had such a short time limit attached to it. Clause 11 only gives the Attorney General, not the victim, an extra 14 days, where the paperwork arrives on day 28. Officials get 6 weeks. The mother of a murdered child still only gets 4. Ministers claim this is levelling the playing field, but it's nothing of the sort. Victims groups, from rape and sexual abuse centres to the Centre for Women's Justice, have pleaded for a straightforward fix. Double the victim application window to 56 days and require the CPS to notify every complainant in writing of the existence of the scheme and of that deadline on the day of the sentence. They asked for time. The government has delivered, on this occasion, bureaucracy. That is Clause 11 in a nutshell, a lifeline for Whitehall and the Attorney General's staff, not for the people we are sent here to defend. Madam Deputy Speaker, let me turn to what the bill does not try to do. The court backlog today is spiralling, and the Ministry of Justice can't yet provide a date in which it will even start to come down. Their permanent secretary, going before the Justice Select Committee, couldn't answer that most basic question for an official charged with leading the service. When is this going to start getting better? There are cases being listed today that are as far away as 2029. Meanwhile, victims are in limbo with their lives left on hold. Justice delayed is justice denied. Today, 74 courtrooms are sitting empty across the country because the Justice Secretary still hasn't taken the Lady Chief Justice up on her offer of extra sitting days. There's barely anything in this bill that will put a dent in the court backlog. Nothing that maximises court sitting days. Not one clause addresses listings, disclosure, or digital evidence. Madam Deputy Speaker, for many people, our justice system is opaque and secretive. I'm a firm believer that sunlight is the best disinfectant, that greater transparency drives change and enforces confidence. There's nothing that enhances transparency on the court backlog, for instance through the publication of the number of courtrooms not sitting each day and why. This falls to start-ups producing websites and apps, not the Ministry of Justice itself. There's nothing in this bill that increases access to court transcripts so that victims, the press and the public can see justice dispensed, an issue given further prominence recently by the public's shock and anger when they heard or read fragments of the transcripts of grooming gang trials. As technology transforms the ability of the courts to provide reliable transcripts using AI, we should provide a better and more transparent service to the public and to the media. This is possible. Why not use this bill to establish basic standards in law for the benefit of every victim across our country? Nor is there anything which mandates the publication of data of offenders by their visa status or asylum status, so we know where offenders are coming from, which we need to design a criminal justice system and, above all, an immigration system that protects the British public. The Victims Commission for London has said that the £1 billion of unpaid court victims' fines is truly astonishing, and that the failure of the courts and tribunal service to recoup outstanding offenders' fines must come under greater scrutiny. Again, this bill is silent on that. There are no extra powers to recoup this money at a time when, without question, the Ministry of Justice budget is under strain. Why not do everything to recoup unpaid court fines, beginning with those? The victims are suffering as a result. Madam Deputy Speaker, we welcome legislation in the name of victims. It must be worthy of that title. Victims have asked for justice that is swift and certain. This bill, in many respects, is slow and tentative. I urge the government to amend it, to strengthen it, so that it really does put victims first, in practice and not just in prose. Where it does, the Secretary of State and the government will have our support for justice and for the victims. Thank you, Madam Deputy Speaker.
Chair of the Select Committee, Andy Slaughter.
Thank you very much, Madam Deputy Speaker. This bill builds on the Victims and Prisoners Act passed by the last Parliament to improve the experience of victims within the criminal justice system, the functions of the Victims Commissioner and more generally the administration of criminal justice. Like its predecessor, it is published against a backdrop of significant court backlogs, with victims of crime too often waiting years for their cases to come to court, and criminal legal aid advocates turning away from the profession. This government is taking steps in tackling those deep-rooted problems, built up over years by the last government's failure to invest in the criminal justice system. But until they are resolved, victims will continue to suffer harm for too long. On the 27th of March 2025, the latest criminal court statistics were published, which showed a record high of 74,651 outstanding cases in the Crown Court as of the end of December 2024. Also in March 2025, the Victims Commissioner published a report titled "Justice Delayed: The Impact of the Crown Court Backlog on Victims, Victim Services and the Criminal Justice System." The report concluded, with the increased number of victims held in the system because of the backlog, victim services are under increasing pressure, which impairs their ability to provide the accessible, high-quality support that victims need. The report called for the government to explore how victims whose cases are going to trial might be given a single point of contact to improve communication and ensure the victims' code entitlements are delivered. It called for the restoration of an independent courts inspectorate so that the operation of the court service is subject to rigorous independent scrutiny, and for providing emergency funding to victim support services to help them cope with increased caseloads arising from the court backlog crisis. The Lord Chancellor wrote to the Select Committee in April in response to concerns that changes proposed by Sir Brian Levison's review will not have a direct impact on delays in the Crown Court for a considerable time. My right honourable friend noted the system requires substantial reform, and the Department looks forward to receiving the independent review of the Criminal Court's recommendations on longer-term structural reform options later this spring, followed by recommendations on the efficiency and timeliness of court processes by autumn. It is against this challenging background, Madam Deputy Speaker, that we debate this bill today. I welcome the measures in it, and I know the ministerial team will use the leverage it gives them to improve the lot of victims in the criminal justice system. But in this, as in every aspect of the Ministry of Justice's work, they have been set a difficult task by past neglect. Let me briefly comment on the main provisions of the bill. Firstly, attendance at sentencing hearings. The bill will provide Crown Court judges with an express statutory power to order the attendance of offenders at their sentencing hearing and sanction those who refuse to comply with such an order, or who attend but then commit contempt by misbehaving or disrupting the proceedings and are removed as a result. They may receive up to 2 years additional imprisonment and/or the imposition of prison sanctions. These proposals have been welcomed by advocates for victims and organisations working in the violence against women and girls sector. However, there are some concerns around how these provisions will work in practice and the implications for judges, court staff, prison officers, prison escort officers and governors. Secondly, restricting parental responsibility. Concerns have been raised that people convicted of serious crimes can retain their parental responsibility unless an application is made to the court to restrict or terminate it. This means, for example, they can potentially ask for school reports, be consulted on medical issues, and withhold their consent to a child going on holiday or being issued with a passport. In last year's King's Speech, the government committed to legislate to restrict parental responsibility for child sex offenders. The new provisions automatically restrict a person's parental responsibility where they are sentenced to 4 or more years in prison for a serious child sexual abuse offence against a child for whom they hold parental responsibility. This means that instead of the non-offending parent or carer having to drive the process, the offender's parental responsibility will be automatically restricted at the point they are sentenced. Thirdly, victims' rights. The bill would update the Domestic Violence, Crime and Victims Act 2004 to expand the eligibility criteria to victims of more offences who would then be covered by the Victim Contact Scheme, create a victims' helpline for some victims not covered by the scheme, expand the definition of victim for the purposes of the scheme and ensure greater consistency for victims of offenders subject to a hospital order. Fourthly, the powers of the Victims Commissioner. In its manifesto, the government committed to increasing the power of the Victims Commissioner. The bill achieves this by allowing the Victims Commissioner to exercise their functions in individual cases which raise public policy issues, placing a duty on local authorities and social housing providers to cooperate with the Commissioner for the purposes of supporting victims and witnesses of antisocial behaviour, and empowering the Commissioner to independently report on the Victims Code. Fifthly, prosecutions. The bill seeks to increase flexibility for the Director of Public Prosecutions in appointing Crown prosecutors. The bill will remove the legislative barrier which is preventing Silex lawyers who have specialist qualifications and more limited rights of audience from becoming Crown prosecutors. Sixthly, costs of private prosecutions. In June 2020, the Justice Committee launched an inquiry into the fairness of private prosecutions and the need for procedural safeguards following a request from the Criminal Cases Review Commission and arising from the Horizon scandal. The committee recommended that the government should urgently review funding arrangements for private prosecutions in order to address the inequality of access and ensure a fair balance between the prosecutor and the defendant. In March 2021, the then government accepted the committee's conclusions and agreed that costs recoverable from central funds by a private prosecutor should be limited in the same way that costs so recoverable by an acquitted defendant already are, by being capped at legal aid rates. It said this would require amendments to the existing legislation, and I'm pleased that at last, through Clause 10 of this bill, the Lord Chancellor is able to make regulations to achieve that aim. Finally, the bill introduces greater flexibility into the unduly lenient sentence scheme, as requested by, among others, the Victims Commissioner for London. There are other technical changes in the bill, but those are the major proposals. I welcome them all. In aggregate, they both assist victims in their progress through the criminal justice system and reform that system to make it more consistent and user-friendly. Madam Deputy Speaker, this is not a panacea for the troubles afflicting the criminal courts. That will require more radical root and branch reform, and for that we await the findings of the independent review. But this bill is a step along the road to a fairer and more humane criminal justice system for victims.
Liberal Democrat spokesperson Josh Babarinde.
Thank you, Madam Deputy Speaker. It means a lot to be speaking about this bill here today as a Liberal Democrat justice spokesperson, but also as someone who has engaged extensively with the criminal justice system as a victim myself. When I came out the other end of a gruelling Crown Court trial as a victim several years ago, I pledged to myself that I'd do everything I could to play a part in fixing a system that too often re-traumatises and punishes victims. When I was part of survivors group therapy with Survivors UK a few years ago, processing my experiences of abuse alongside 11 other brave men, some of whom are watching on today, I swore to those lads that I would never forget their stories, and I would do what I could to help transform our pain into justice for victims and survivors for the future. And when I meet victims of crime who come to see me for help in my constituency of Eastbourne, I promise them that I will throw the kitchen sink at fighting for the support that they need and deserve. And so my contribution today is for all of them. And I say on their behalf, Madam Deputy Speaker, that it's time to shift the centre of gravity back to victims in our criminal justice system. It's time to give victims their voices back. It is time to dignify victims' experiences with action. That's why Liberal Democrats fully support this bill's efforts to address, for example, the horror of children still being subject to parental responsibility of those deplorable parents who were convicted of serious sexual offences against them. That's why we welcome the proposed Victims Helpline, eligible for victims sentenced, whose perpetrators are sentenced, regardless of the length, so that they can get information about those perpetrators, release and so forth. And this will go some way to help address some of the concerns I've expressed about the shortcomings of the existing victim contact scheme. And so I thank the government for taking that feedback from myself and many other members and groups on board. This is why Liberal Democrats also welcome the bill's measures to strengthen the powers of the Victims Commissioner, empowering them almost to act more like an ombudsman who can take up the causes of individual victims where it is in the public interest. And that is why we agree that defendants should participate in sentencing hearings, because robust rehabilitation necessarily involves facing up to one's actions and understanding the impact of them on their victims. But, Madam Deputy Speaker, Liberal Democrats believe that this bill could be even more ambitious for victims and survivors. And so that's why, together with supporting this bill in the remaining stages of the legislative process, we'll be challenging the government to address some of the serious omissions that stand to leave victims without the protections that they need. And the first, and I know the Minister knows it's coming, is on domestic abuse. Liberal Democrats have highlighted that this government has inherited a scandalous state of affairs where the state does not know how many domestic abusers there are behind bars. The government does not know what the reoffending rate is of domestic abusers in our criminal justice system. And the reason is because there isn't a specific identifier in our system, whether it is an offence or whether it is something else. And so since November of last year, we've been screaming out for the government to deploy robust measures to officially identify domestic abuse perpetrators on a statutory basis so it can better protect victims and survivors. I'm genuinely grateful that this government has agreed to seriously develop a way of that identification. I know that work is happening behind the scenes, but I'd like to ask the Minister to confirm on the record whether we can work together to achieve this on this bill, or if not on this bill, which piece of legislation in future we might be able to see some progress on this. The second gap is on court transcripts. Victims and survivors need measures that deliver fair access to court transcripts. The Shadow Justice Secretary forgot to mention that my honourable friend, the member for Richmond Park, has led the way on the issue in this place, repeatedly urging the government, the past government, to make permanent the pilot scheme. And indeed this. Of course.
Honourable friend. I have one of my constituents who's been a victim of domestic abuse has written to me actually about the work that Sarah has done, and so that has resonated across this country, I believe, and she herself has said that actually that access to transcripts was difficult. She welcomed the pilot from the Ministry of Justice but said that actually the communication around that for victims was not good enough, and so would my right honourable friend agree with me that whatever work is done we need to make sure that victims are communicated to know what powers they have to access the information they need.
As a reminder, members do not refer to colleagues by their first or second names, but by their constituencies. Josh Babarinde.
I thank my honourable friend for that intervention, and she's absolutely right. Not only is it critical that victims' rights are strengthened, but it's critical that victims have the knowledge of those rights and entitlements so that they can invoke them and enforce them and benefit from them fundamentally. But my honourable friend from Richmond Park has been urging the government to make permanent the pilot scheme that affords victims of rape and other sexual offences a record of their sentencing remarks free of charge. And she's been campaigning on this for years, not just when the populist bandwagon is in town, like some others in this House. And ahead of this pilot scheme ending imminently, we must not return to a world in which some victims are charged up to a staggering £22,000 just to see a write-up of their case. This is exclusionary justice delivered at an eye-watering price. And so, as well as campaigning for the pilot to be extended, we would push the government to expand it to cover a far wider pool of victims and survivors. And on a similar note, as a constituency MP, I want to encourage the government to take steps to encourage not just written records, but audio-visual records of court proceedings to be made available to victims and survivors. A mother came to a constituency surgery I ran recently, sharing that her son, who has special educational needs and is non-verbal, was restrained in home-to-school transport, and legal proceedings were kicked off as a result. The mother did not get to see the video evidence of this until the court case and has no access to that harrowing and traumatic evidence since then, but she ought to have the right to it, and I hope that the government could be able to help us on that basis. A third gap is on national insurance contributions. We need support for victim charities who've said that the hike in the last budget will take their services and victims who rely on them to the brink. Another gap is on family courts. We need measures to prevent abusers from using parental alienation proceedings to perpetrate their abuse. A fifth is on the court backlogs, which leave so many victims in the lurch for years. When can victims expect to see measures to tackle court backlogs? In conclusion, Liberal Democrats are concerned that these gaps in the bill could risk overshadowing many of the decent measures that I know ministers have been working hard on. And so we look forward to supporting this bill and its efforts to ensure that victims are heard, protected and respected. We'll challenge the government to go further and faster to ensure that victims and survivors get the support they deserve and ensure that they do not pay the price for the neglect they're subject to under the last government.
And there are many colleagues hoping to contribute. So after the next speaker, there will be a speaking limit of 4 minutes, just to enable you to prepare. And I call next Anneliese Midgley.
Thank you, Madam Deputy Speaker. And today I speak to one part of this bill that will require convicted offenders to attend their sentence hearings and provide consequences where they refuse. It's known as Olivia's Law. Olivia Pratt Corbell was 9 years old when she was murdered in her own home by a stranger with a gun. The murderer, Thomas Cashman, fired a bullet through the door of Olivia's home, which passed through the wrist of my constituent, Cheryl Corbell, Olivia's mother, before hitting Olivia in the chest and ending her life. Cheryl and her cousin, Antonia, are with us in the chamber today. Madam Deputy Speaker, to lose a child to murder in your own home while trying to protect them is a burden no parent should ever be asked to bear. But under our current justice system, convicted criminals can opt out of attending their own sentencing. That's what Olivia's murderer did. Cashman remained in his cell, refusing to face the court, to hear Cheryl's words, to look her in the eye. It was the act of a coward. That injustice must end. Nothing in this world can bring Olivia back. But instead of collapsing under this weight, Cheryl fought back. She and her family have campaigned, so no other family would suffer the same. Olivia's Law is her work. It's Olivia's legacy. It's Cheryl's legacy. Madam Deputy Speaker, today I will read out Cheryl's victim impact statement. These are the words the murderer, the coward, Thomas Cashman, refused to hear. I want the words of Cheryl Corbell committed to this House, so they will be on record in this place forever. Let her words ring out in this chamber, like they should have done in Cashman's ears that day. Olivia was born 6 weeks early, on the 13th of June 2013, at Wiston Hospital, weighing 4 pounds and 2 ounces. She was so tiny. She fitted in one hand. She had the most beautiful tan skin. There wasn't a blemish on her. The tiny little bundle grew into a toddler, having the most perfect chubby rolls on her legs. And every time we went out, we were stopped by anyone and everyone saying how beautiful she was, especially her big, beautiful brown eyes and thick, curly hair. Ryan and Chloe adored her as their baby sister. She slept in my room until she was 1. And then she moved into the big room with Chloe. Liv wasn't the best sleeper, and she would wake up of a night. And often by the time I got to her, Chloe was already up and soothing her. Chloe was like a second mother to Liv. The years passed by too quick, and Liv started nursery. She was loved by everyone. She loved to play, in particular playing house and princesses. Cinderella was their favourite, and at home, she would dress her dog Gizmo up in a blanket and put him in a pram, pushing him around the house. Gizmo still brings that blanket into me now. More years passed, and Liv skipped into her first day of reception. I was heartbroken, but she was happy and content. I couldn't believe my baby was going into big school. She loved helping others, and especially the role of being the teacher's helper. She had a special bond with one of her teachers. Liv was such a social butterfly. She was particularly good with younger children and such a caring little girl. Liv had really long, beautiful brown hair, something she was very proud and particular about. And a few weeks before she was cruelly taken away from us, Liv had heard about the Little Princess Trust and what they do from a friend in school. After talking to me, Liv decided she wanted to donate 12 inches of her hair, in her words, for the sick kids to have beautiful wigs. We then went online together and applied for the sponsorship form. Liv was due to have her hair cut on the 27th of August. Liv was a girly girl and loved to play with makeup. She loved shoes with heels on. She didn't want to wear trainees ever. She had her own style and would wear what she wanted to wear, even though it often didn't match. She would go to our Tony's house with the girls and come down in the clothes and say she'd just found them. Those clothes would make their way to our house and the girls would never see them again. And as Ryan and Chloe got older and began doing their own things, it became mostly me and her on my own. She was nicknamed My Shadow. We were just always together, me, Liv and Pearl, her purple bear. This was once Chloe's bear, but Liv took a liking to it and decided it was now hers. Pearl was her comfort blanket. Each evening was different with Liv. One night we could be watching Matilda while she was upside down on the couch. And the next night she would leave me watching H2O while she sneaked upstairs to Ryan's room while he was out, so she could lie on his bed watching YouTube on her iPad. Liv never stopped talking, literally never. Even if she wasn't talking directly to anyone, she'd just be chatting away. And one thing I miss most is hearing her say, Mum. I just miss her and her voice. It's just so quiet. I would do and give anything in the world to have her chatting to me. It's so very lonely without her. Everything is just so quiet. I just can't cope with the silence. Setting my alarm at 7:30 in the morning is something I still do, because it's ingrained in me. The day goes by in a blur, then it gets to 2:30 and I think about school pickup, something I will never do again as a mum. She wasn't, always will be, my baby, but I miss the routine we had. My mind keeps telling me that I've forgotten to pick her up from school. Now tea time was a big thing for me because it was centred around her and what she wanted for tea. Everything I do and everywhere I go is a constant reminder that she is not there with me. This happened in our home where we felt safe and should have been safe. We had no choice but to leave the home. That was Liv's first and only home. And when the police left, we weren't allowed back there. It was heartbreaking. I walked in. It was a time, stood still. Cups of tea still sitting on the coffee table, next to a Little Princess Trust sponsor form. Liv's new bike, propped up on its stand. One of her dolls laying on the living room floor, and a brand new sparkly shoes in a box. Right at that moment, I was home. We were back to how our lives were before that night, and I soaked up the surroundings until reality dawned and brought me back to my living nightmare. Packing up our home was horrendous. Having to pack up our lives, having to strip Liv's bed, pack her clothes, toys, jewellery and memories into a box. No mother should ever have to do that. We left our friends, our neighbours. My neighbour Chris was amazing, and often when I needed to go to work would sit with Liv until Chloe got home from college. It's hard to go back to the area where I grew up and where I raised all my 3 children, the area where some of my closest friends live. The smallest of things remind me of Liv and friends playing in the street. When I see them, it's hard to accept. She's no longer there. Moving into the new house was difficult for all of us. Not being able to make a bed, put her clothes away, the toothbrush in the bathroom, and not having a favourite food in the fridge. And that night, when I realised Liv had been shot and needed me, I was not able to do CPR properly on her because of my injury. I did not have full use of my hand and I felt helpless. It was only then my neighbour came in and tried all he could to save my baby. My worst nightmare was being separated from Liv and not being with her when she needed me the most. I was the first person to hold my baby girl, and as her mum, I should have been the last. I cannot get my head around how Cashman continued to shoot after hearing the terrifying screams, the utter devastation he has caused. He doesn't care. How could he? His actions have left the biggest hole in our lives that can never be filled. That man set out to do a job, and he didn't care about anyone else or who got in the way. He certainly couldn't own it either. Ryan, Chloe and I are just existing day to day and have been since it happened. We've been waiting for the trial and focusing on it and not addressing how utterly broken we are as a family. I cannot even think about rebuilding our lives without her. Because of this, we've missed out on so much. My nan, who was 92, adored Liv and Liv her. Recently, my nan's health deteriorated and she was admitted into hospital. A couple of weeks ago, we were able to bring her home on end-of-life care. Due to being in court every day, we have not been able to spend enough quality time with her. My main focus has been on getting justice for Liv. I believe she held on long enough to hear that that coward had been found guilty. Sadly, my nan passed away last night. My 9-year-old Liv was the light of our lives, our beautiful, sassy, chatty girl who never ran out of energy. She was a character. She was my baby. She had amazing qualities and knew what she wanted in life. She will never be able to get to make her Holy Communion, wear that prom dress, or have a sweet 16th birthday, walk down the aisle with the man of her dreams, or become the mother of her own children. All that promise of her future, so cruelly taken away. Now I have to drive to the cemetery to be close to my baby daughter. I sit with her and talk to her, telling her I miss her smile, her kisses, her cuddles, her voice. I tell her she will live on in my heart. She will always be with us, my little shadow. We love you endless amounts, Liv. Madam Deputy Speaker, let Cheryl's words be heard. Let them be honoured. Let Olivia's law pass and make sure that no victim's voice is ever shut out of justice again.
Yeah. Can I thank the Honourable Lady for sharing that with us? It was important that the House heard that. Sarah Bool.
Thank you, Madam Deputy Speaker, and can I just pay tribute to the absolutely very powerful tribute from the member of Knowsley just then, and our thoughts and prayers are really with Liv's family in the gallery. I truly do welcome the provision of better information for victims of crime. It is absolutely essential that victims are at the heart of justice. As Baroness Newlove has said in regard to domestic abuse, victims of survivors of domestic abuse must be able to trust in the criminal justice system, that it will provide a robust, trauma-informed response that prioritises their safety whilst holding perpetrators to account. We must ensure that victims feel that they will not only get justice, but can trust the system. And we need to restore trust and confidence in our system. So I am very glad to see that this bill will bring forward more for victims in the scope of the Victim Contact Scheme. They must be given more information on the offender's upcoming release or the discharge of licence conditions, and this includes notification of key events like transfers to open prisons. One of my constituents raised with me the case of a domestic abuse survivor who, along with her unborn child, survived an attempted murder by her ex-partner. Although he received an 18-year sentence in 2016, in March this year he was eligible for open prison placement 4 years earlier. And it was incredibly distressing. As they often say, perpetrators of domestic abuse know everything about their victims. They know where they live, where they work, and where their children go to school. And it is absolutely terrifying for victims to find that perpetrators are being released potentially early and that they cannot be prepared for this. But I also do want to see parole boards involved in decisions regarding open prison placements for domestic abuse offenders to ensure that victims' voices are heard. Now, it was said earlier on that timely access to justice is key, but confidence is also too, and I think we have to be very careful about the language that we use. We must ensure that all victims trust our legal system, and I fear some discussions do more harm than good. Thank you.
Elsie Blundell.
Thank you, Madam Deputy Speaker. I would like to begin by thanking my right honourable friend, the Lord Chancellor, for bringing forward this much-needed piece of legislation which will change our justice system for the better, strengthening support for victims and holding those who violate our laws to account. In my constituency of Heywood and Middleton North, the scars of serious crime and antisocial behaviour and of an inundated court system hold back our communities. My constituents and people across the country are looking for answers to these challenges rather than the posturing we see all too frequently in some quarters today. I believe that this bill goes a long way to providing them, and I know that these changes will be truly welcomed in my constituency. Last week I held a town hall event focused on crime and antisocial behaviour in Scotland, an area that I am proud to represent and to relay concerns from today. I'd like to place on record my gratitude to all of those who attended and who gave their stories, as well as those from Rochdale Borough Council, Greater Manchester Police and Rochdale Borough-wide Housing who also attended and were questioned by local residents. We covered a vast array of issues in a constructive and thoughtful manner, and I believe we got to the crux of what keeps people in Scotland and across my constituency awake at night, ultimately the safety and security of their families and loved ones. Across our borough, stalking offences, dangerous driving, off-road bikes and drug crime have been growing in prominence, and in Greater Manchester, our court backlogs are some of the largest in the country. Most people I spoke to at that event were weary after years of cuts to essential police presence and after consistent underinvestment in our courts. They have seen a system built to protect them pushed to the brink and are unable to respond effectively to the changing nature of crime in our communities. But despite the challenging nature of what we discussed, I didn't come away disheartened. On the contrary, I came away hopeful and determined to take their concerns forward. Communities are rarely unresponsive or idle to the challenges they face. In fact, they want to be part of the solution. People in my constituency want to work alongside authorities and local leaders to make our streets safer, to make sure that victims are supported and perpetrators face the full force of the law. They want common sense and considered interventions from government like the ones that we see before us today. I would like to touch on one of the provisions in this bill that I believe will make a real difference to the communities that I represent. Firstly, that the shadow of on-street grooming still hangs over families and survivors in my constituency. This is alongside wicked present-day crimes which are perpetrated against children across the country, the cruelty and cowardice of which remain with victims for life. According to the Centre of Expertise on Child Sexual Abuse, 500,000 children will experience some form of child sexual abuse every year in England and Wales. And we also know that 1/3 of childhood sexual abuse offences are committed within the family environment, and we must make sure that children who are exploited or abused no longer remain under the responsibility of a family member who is capable of committing such vile acts. That is why I commend the provisions of this bill, which will restrict parental responsibility for offenders who are sentenced for abusing young children. Families themselves must feel they have a place to turn when this unimaginable violation befalls a loved one and feel supported in law. Minimising bureaucracy and limiting procedural burdens in a way which mitigates further distress being put on families so that they can begin to rebuild what those perpetrators have shattered is a step that I wholeheartedly support, as I do other measures in this bill, including the provision which mandates that perpetrators attend their sentencing hearing or face further penalties. As we know, crime does not just exist at a single point in time, its implications live on for victims, sometimes forever. Neither is it faceless. Behind each criminal act is a perpetrator who should face the consequences of their decisions, and they should be made to look at the damage that they have done in a person's life and hear the verdict on their crimes. This bill gives victims agency.
Sarah Olney.
Madam Deputy Speaker, before I start, can I just pay tribute to the member for Knowsley for that incredible speech, and to Olivia's family and to the government for listening to that call and to including that requirement, that provision in the bill. I want to talk a little bit more about provision for victims, and particularly my court transcript campaign. The Minister knows that this is coming, and I'd like to thank the member for Eastbourne for his very generous tribute earlier on. I'm really disappointed there's no mention of court transcripts in this legislation. Trials are lengthy and traumatising experiences, and victims are routinely do not attend, and some are actively advised against doing so. Being able to review the sentencing remarks can help provide victims and survivors with clarity and closure, but too often accessing these sentencing remarks is unaffordable and only adds more barriers to achieving justice. And that's why providing victims and survivors with free access to copies of their transcripts was an issue that I campaigned on throughout the last Parliament. I'm glad that my open letter to the former Justice Secretary received support from the then Mother and Father of the House, as well as the former Chair of the Justice Select Committee, and I was glad to have cross-party signatories to my amendment to the Victims and Prisoners Bill in the last Parliament, which would have, if accepted, enabled all victims to receive a transcript of both sentencing remarks and judges' summing up free of charge. Despite broad support, this amendment was ultimately unsuccessful, both in this House and again in the other place when a similar amendment was tabled by my colleague Baroness Brinton and was blocked by 187 Tory peers. Now, given the previous government's refusal to address this gross inequality and their inexplicable opposition to this policy, letting down victims and survivors, I've been interested in the Conservatives' change of heart on this issue, noticing the shadowed Minister's recent support for this, as well as the member for Goole and Pocklington raising the accessibility of court transcripts to the Justice Secretary last month. I'm glad to see indications that they may finally be acknowledging the extent to which the last government failed victims. Now, following my campaigning on this issue and the invaluable work of campaign groups working to support victims, I'm glad that this government have introduced a 12-month pilot scheme. Now, this scheme, a 12-month pilot scheme was introduced in May last year. This scheme gives victims of sexual assault and rape access to obtain copies of court transcripts of their trials at no cost to them. Now, victims and survivors made use of this pilot report that its impact has been transformational. Yet in a recent response to my question on this issue, the Minister responded saying they were assessing the pilot's uptake and impact and would say more on their plans for future provision in due course. Now, as I'm sure the Minister is aware, last week I introduced a bill to the House which called for the Rape and Sexual Offences Free Sentencing Remarks pilot scheme to be made permanent. And my recent early day motion on this issue has also received cross-party support, which sets out broader calls which would expand the scheme to cover all victims of crime. Now, if the government does not intend to make the scheme permanent, not only will they be failing these victims, but they will also not be upholding the commitment made in the King's Speech last year to strengthen support for victims. I've heard directly from constituents of mine who've accessed their transcripts, having not attended the trial, as well as from members of the public from across the country who've been through similar experiences, and they have told me of the hugely positive impact that accessing a court transcript has had on them and their journey. With just 8 days until the scheme is due to end, and given I'm still awaiting a response to the letter that my honourable friend, the member for Eastbourne, sent to the Justice Secretary on this issue, I wish to now ask if the Minister will outline future plans for this scheme and urge them to make the support for victims permanent. And I will ask the Ministry to make clear on what basis it's discontinued this scheme. I welcome so many of the measures in this bill. I really welcome the additional support for victims that's contained in this bill, and I really do hope that as the bill continues through the House, we can make further amendments to extend this scheme and make it permanent. Thank you, Madam Deputy.
Natalie Fleet. Thank you, Madam Deputy Speaker. I declare an interest as a member of the Women and Equalities Committee. Rape survivors are too often hidden in plain sight. In Bolsover, my constituency, 10,554 women will have been raped or sexually assaulted since they were 16. A third of these will be in their own homes. Shirebrook, Tibshelf, Wessington, Balborough, every village and town in between. 5,277 of them will have been raped more than once. 880 will have reported, and if we're lucky, 26 will have been charged. I've got permission to share the experience of one of the wonderful constituents who reached out to me. She said, "I was spiked in a hotel and sexually assaulted in a room where I thought I would be safe. As a result, I lost my job. My marriage nearly crumbled, and I lost 6 of my son's most formative years because my brain shut down completely and I went into survival mode. We need to raise our boys better, to respect and work alongside women without judgment or expectation around sex. She is right. But this is not just a Bolsover problem, this is a society issue. Rape is a part of our national story, a part that we are not telling. We cannot continue with a culture where he did it and she hid it. Women don't report because they have been let down by the courts for too long. Like another of my constituents, 4 years and 5 months from rape to trial, multiple suicide attempts. I am so pleased that this government is doing something about it and treating violence against women and girls as the national emergency that it is. The measures in this bill mean that victims of crime will finally be put first. But this bill is also our opportunity to put a full stop on a lifetime of ongoing trauma. I will keep speaking about the 10 babies born every day to their mummies that have been raped. 6 children in my constituency every year, and in every constituency across England and Wales. We see these children hidden in plain sight on our school visits. We see them as adults in the workplace. They drink amongst us in the pub, but their brave mothers have hidden their existence throughout history, often even from them. The mums tell me about the struggle to bond with the babies that look like the man that hurt them. They tell me about the pain of loving their children and also wishing they didn't exist. They tell me about living with the threat of their rapist being part of their lives forever. One survivor said she could not report the crime because if she did, the perpetrator had told her that he had parental responsibility and he would use it. Being charged, going to prison, nothing would take away his rights around the child conceived when he raped her. This bill is our opportunity to change that. I call on our government to remove parental responsibility where a child is conceived via rape. Our precious children can no longer be the only proceed of crime a criminal has lifelong access to.
Katie Lamb. Thank you, Madam Deputy Speaker. It is a privilege as a Member of Parliament to support our constituents in their hours of greatest need. All too often, this is when they are a victim of an appalling crime. Many of the constituents I speak to are at their wits' end. They are desperate to be heard, helped and protected. They rightly want their tormentors to be made to stop, and they want justice. Many of the steps taken in this bill will be welcomed on both sides of the House and by victims across our country. It is right, for example, that we restrict the access that convicted sex offenders have to their children, and it is right that we give victims more information about their offenders' release. However, Madam Deputy Speaker, the calls for justice for the victims of grooming and rape gangs grow only louder. Across this country, people are rightly horrified by these crimes and the subsequent cover-up, which represents the biggest national scandal in our history. Yet the government has failed to use this opportunity to deliver real justice for those victims and survivors. Last month, I spoke in this place of the details of just some of these disgusting crimes. I was able to do so because of the organisation Open Justice UK, which has purchased, redacted and published transcripts from some of these court cases. But they have been refused permission to do this in several instances because a judge has claimed there is no public interest in doing so. This is wrong. Of course, we must make sure that the anonymity of victims is protected, but nobody is suggesting doing anything to compromise that. These were public trials held in open court, and at the moment these transcripts represent the only way to get to the truth of these revolting crimes that have been carried out across Britain for far too long. I give way.
John Hayes. Giving way. And isn't the answer to that, in part at least, a national statutory inquiry into what occurred? Not least because we don't actually know whether it's still going on, and that inquiry would expose so much which would allow all those right-thinking people to take the action necessary and protect so many of the people who might be at risk from further horrors.
Thank you, and I can only agree with my right honourable friend. It is appalling that this is currently the only way to understand what has happened in these cases. And relatedly, as my right honourable friend, the member for Newark, has previously said, these aren't just legal documents, they're historic documents that tell the story in detail of some of the worst crimes in our recent history. This bill acknowledges that transparent information about our justice system is in the interests of victims, yet does nothing to address this problem. What's more, due to the current limits on appeals against unduly lenient sentences, many victims of these horrific grooming and rape gangs will be denied a vital opportunity to seek real justice. In far too many of these cases, we have seen courts hand down lenient sentences. For far too many victims, there will be no redress and their abusers will walk free. Often, after just a few short years, these monsters will be back in the communities they came from, walking among us and walking among their victims. Just last week, the Court of Appeal revisited the case of 3 men who were convicted of raping a teenage girl in Yorkshire. Ibra Hussain and brothers Imtiaz and Fayed Ahmed were convicted in January for committing unspeakably evil crimes against a 13-year-old girl. In the first instance, they each received sentences of less than 10 years. As my right honourable friend, the member for Newark, mentioned, he and my honourable friend, the member for Keighley and Ilkley, referred this case to the Attorney General. In this instance, the court rightly ruled that these sentences were far too short. This bill should have made it easier for victims to seek the same redress. It does not.
Will you give way?
I give way.
This government
Elsie
has announced... Thank you. This government has announced specific support for 5 local inquiries and is getting on with the implementation of the recommendations of the J report. Would the honourable member opposite like to comment on what her government, the previous government, did on this subject?
Lamb. Thank you, Madam Deputy Speaker, and I thank the honourable member for her intervention. There's 2 points, perhaps, that I would like to make on the point that she's making. Firstly, 5 local inquiries is nothing like enough. There were 50 towns where this took place, and all of those victims deserve justice. Secondly, there are trends across the country, and only a national inquiry can get to the bottom of those. And thirdly, she mentions the J inquiry. Inquiries are very often specific. The Hillsborough inquiry did not investigate every football match. The infected blood inquiry did not look at the whole of the NHS. The Manchester Arena inquiry did not address every terrorist attack. There has been an inquiry into child sex abuse, but that is not a specific inquiry into the specific phenomenon of groups of mostly Asian Muslim men grooming and sexually torturing mainly white children, facilitated and covered up by those in the British state whose job was to look after them. That is a specific phenomenon, a particular stain on our country, and it deserves a dedicated inquiry.
It does.
I am coming to the end. Madam Deputy Speaker, I am sure that the Lord Chancellor and the Minister here today want fairness for victims. So will they please amend this bill? Firstly, to offer the independent national inquiry into grooming and rape gangs that the country and victims need. Secondly, to ensure that all such transcripts, appropriately redacted, be made available for the public to see. And finally, to allow victims greater ability to appeal the shockingly short sentences that we see all too often.
Kim Johnson.
Thank you, Madam Deputy Speaker. I'd like to start by paying tribute to Liz family and Cheryl's very powerful statement. But I want to focus on the victims of state violence and the fact that they're missing from this bill. I want to start by remembering the 97 victims who perished in Hillsborough and their families who have been through so much and fought for so long for justice. And I want us to remember today our government's commitment to these families to bring in the long overdue legal duty of candour on public officials, otherwise known as Hillsborough law. This bill, as it currently stands, is a major missed opportunity to make good on this promise and finally deliver justice for the 97. We have failed to meet our own self-imposed deadline for this year's 36th anniversary. A painful moment for Liverpool, made yet more painful by broken promises and the threat that this commitment may be watered down when it is eventually brought forward. The core of the Hillsborough law is straightforward: a statutory duty of candour on all public bodies and officials. That means that when incidents occur, those in power must proactively tell the truth, share all relevant information and cooperate fully with investigations and inquiries. No more defensive PR operations, no more smear campaigns against victims, and no more families faced to battle the system for decades just to have their loved ones' names cleared. Without a full Hillsborough law, the cycle of cover-ups will continue, from Grenfell to the infected blood scandal. We have seen time and again that institutions act to protect themselves as a priority, leaving ordinary people to pay the price. This bill is an unmissable opportunity for this government to make good on their promises, and I hope the Minister listens to the strength of feeling and brings back a government-backed amendment that implements a full legal duty of candour on public officials. I also want to take the opportunity to raise the important inquest campaign for a national oversight mechanism backed by 70 organisations. It has been tabled as a private member's bill by the Honourable Member for Bristol, currently making its way through this place. Public and private bodies have a duty to keep us safe from harm, but every year hundreds of people die, preventable state-related deaths. The lack of any mechanism for learning from past tragedies is a huge part of this. So when someone dies after contact with the state, hundreds of vital recommendations are made following inquests and inquiries. These include deaths of people in police and prison custody, mental health settings, and following disasters at Grenfell and Hillsborough. These families need transparency, accountability, and action so that changes are made to prevent future deaths in similar preventable circumstances. Introducing a mechanism would be a watershed moment for families bereaved at the hand of the state, and it would be unforgivable for us to miss this opportunity this bill pretends to bring forward this mechanism. So when it comes to victims of state and public bodies, the details in this bill are severely lacking, and I hope the Minister will listen to the points I raise and come back with some government-backed amendments to improve accountability and oversight mechanisms to ensure justice for all tragedies at the hands of the state. Thank you.
Liz Jarvis.
Thank you, Madam Deputy Speaker. I welcome this bill as an important first step towards a more accountable criminal justice system, one that reflects the needs and voices of survivors of crime. Too often, victims have been let down by a system that fails to grasp their trauma and recognise their experiences. They are expected to navigate an underfunded and overstretched justice process that all too frequently delays or even denies justice. So I sincerely hope this bill is just the beginning of a wider governmental approach to fix the crisis in the criminal justice system, including the court backlog and the mess left behind by the previous government. Liberal Democrats support the creation of a specific domestic abuse aggravated offence, and I'd like to pay tribute to my honourable friend, the member for Eastbourne, for his tireless work on this issue. In February, 2 men from Hampshire were released as part of the prisoner early release scheme, even though they were both convicted of domestic abuse. The former partners of these men said they were terrified and felt unable to regain control of their lives. One of the victims said, "He got 3 years, I got life." The law should be changed to reflect the full impact of domestic abuse on its victims. Madam Deputy Speaker, recently I met with a constituent whose ex-husband was convicted of sexual communication with a child, yet he was permitted to change his name. Despite the Crime and Policing Bill requiring registered sex offenders to notify police and seek permission before changing their name, serious risks remain. My constituent's case highlights how sex offenders can conceal their identities by changing their name. I know this issue was raised in the last Parliament by the Honourable Member for Rotherham, but I would ask the Minister if this government will take action to protect victims and survivors from this loophole that allows registered sex offenders to change their name to avoid detection. Madam Deputy Speaker, I am glad the government is taking steps to support victims and survivors of crime. I hope more will be done to ensure the criminal justice system truly protects the most vulnerable and delivers justice that is accessible, fair and centred on the needs of those it is meant to serve.
Alex McIntyre.
Thank you, Madam Deputy Speaker. May I also pay tribute to my honourable friend, the member for Knowsley, and to Olivia's family for how powerful their campaign has been on this. This bill seeks to challenge the imbalance of power between perpetrators and their victims that has long existed within our justice system. For too long, offenders have held the upper hand, and I'm proud that this bill and this government will finally put victims first. It will strengthen our courts, reinforce the core principles of our justice system, and provide greater protection for victims of crime. It will grant our courts the power to order offenders to attend their sentencing hearings, using reasonable force as necessary, and extending sentences and imposing sanctions in prison for the cowards who refuse to face up to what they have done. Once and for all, our justice system will ensure that those who commit crimes are held fully accountable for their actions. And it will strengthen the role of the Victims Commissioner to monitor and report on compliance with the Victims Code, and in doing so it will drive meaningful, lasting change, ensuring victims' rights are not only recognised but firmly upheld. Now, at its core, this bill is about shifting the balance of power, moving it away from offenders and placing it in the hands of victims and survivors. It is about safeguarding the rights of every person across our country. Now, the Shadow Minister is not in his place now, but he said he wants transparency. Well, let's give him some transparency on the last government's record on justice for victims. Because 10 months ago, this government inherited a justice system in crisis. The last Conservative government shamefully left our prisons on the brink of collapse, with a backlog in our courts and a justice system that failed victims up and down this country. Shockingly, 60% of those who reported rape dropped out of the criminal justice system. We know from my honourable friend for Bolsover how few of those are actually reported in the first place, and that they drop out before getting to trial and are often re-traumatised by the system. Now, it's a shame the Shadow Minister is busy, perhaps with his leadership bid, too busy to hear what I'm just about to say, but justice under the Conservative Party means more offenders escaping justice and fewer victims receiving. They don't like to listen to it, but that's their record in government. Now, as many members across this House will know, we are sadly facing an alarming rise in domestic abuse. Sadly, in Gloucester, we're all too aware of that scale of the crisis. In December last year alone, nearly 250 arrests were made relating to domestic abuse in Gloucester. Now, given how desperate and widespread this issue is, I am proud that the measures in this bill will help deliver justice for the 1 in 4 women and 1 in 7 men who have experienced domestic abuse, and for the constituents I represent who both need and deserve that justice. Now, from speaking to survivors and victims of domestic abuse in my constituency surgeries, I particularly welcome the changes this government is making to ensure victims receive information and support, particularly about their offenders' release. And I hope that this will be part of wider reform of the parole and tagging system that has led to far too many of my constituents being let down in the past. I am inspired by the pace and ambition of which this government is delivering its ambition to tackle and halve violence against women and girls. But if, on the off chance, the government would welcome more ideas on how we can better support victims, then I would welcome my honourable friend, the Minister, taking this opportunity to back my domestic abuse safe leave bill. Like this bill, my bill also aims to place power in the hands of victims and survivors, supporting them as they seek justice and to rebuild their lives. Today's bill, however, brings us a step closer to halving violence against women and girls and delivering the transformative plan for change that our country and constituents so urgently need, and I look forward to voting in favour of the bill later today. Thank you.
Liz Saville-Roberts.
Then I too would like to pay tribute to the honourable member for Knowsley for speaking so movingly about Olivia and her family. And I rise primarily to speak about the victim-centred measures in this bill, and would like to take the opportunity to thank the Minister for Victims and Domestic Abuse for her engagement with me on this matter, and also with my constituent Rhiannon Bragg, a formidable activist who has done so much work to improve support and services for victims. The expanded victim contact scheme should see more victims able to get adequate information about their offenders' sentences and make representations about licence conditions or supervision requirements as they relate to them. Similarly, the victim helpline will give more victims the information that they need. I truly welcome these measures, which the UK government says will cost an extra 0.2 million for HMPPS each year. Now, updating the Victims Contact Scheme, I am informed, will cost £20,000 a year, and between £100,000 and £200,000 for the Victims Helpline. I am somewhat concerned about these costings as whether they will be sufficient. And as the co-chair of the Justice Union's parliamentary group, I would call on the government to commit to delivering additional resources to the probation services, and as unnecessary for these additional services, to deal with the demand that is inevitably going to increase, initially at the first instance, and as victims become more aware that, of course, they have these rights. There is, of course, within probation a risk of overextending a service that is already in a workload and staffing crisis at the expense of victims. Extending the powers of the Victims Commissioner is also welcome, of course. Victims should always feel secure that the Commissioner can and will do everything in their power to tackle shortcomings where the victims live. That is why I'll continue my call for a Victims Commissioner for Wales to represent victims of crimes in the specific context of Wales, where, of course, many victim support services and important policy levers such as health and social care are devolved and are held account to by the Senedd. At this point, I would also mention another aspect of this bill, the Crown prosecution recruitment. If we could, the government could seek to have personnel who can operate in Welsh and English, because we need such personnel within the criminal justice system in Wales. Of course, devolving the entire criminal justice system in Wales, as recommended by 3 independent commissions, would be the best way to ensure a Wales-focused approach to victim support. But in the meantime, a Victims Commissioner for Wales would ensure that the particular voices and experiences of people, of victims in Wales are properly represented. We need only look, of course, to the fantastic work done in London by the London Victims Commissioner, Claire Waxman, to see exactly what is possible when you have a fully focused approach. Therefore, to close, the Victims and Courts Bill is a good basis on which to build. There are always ways to go further, to better support victims, particularly in Wales, and I look forward to seeing how this develops with amendments at committee stage.
Arlington.
Thank you, Madam Deputy Speaker. Given the time limit today, I first of all just wanted to say a huge thank you to the Victims Minister, the MP from Pontypridd, the Solicitor General, and ably supported by our amazing female team at the Home Office as well. I won't go through everything that is fantastic about this bill, because it really is, and it is this once-in-a-generation opportunity to improve things for victims. I just wanted to bring up 3 issues that I think would make it an even better bill. And, you know, my honourable friend from Pontypridd says she's always open to new suggestions. The first one I wanted to mention is the unfair use of the so-called bad character evidence. This allows the cross-examination of rape victim survivors about their previous sexual assaults. This has nothing to do with the court case that's in front of them. This is about victim blaming. It's about intimidating the victim, and it's about making the victims afraid to go to court. I think that this is something that very much would improve this bill if we did not allow these so-called bad character evidence to be used in these proceedings. Secondly, we need to recognise, as is in law, that victims of domestic abuse are also victims of coercive control. Part of that coercive control can include things like taking out loans in their names, but sometimes, in extreme cases, it's about coercing them to actually break the law. We need to have a way that the court can recognise that when a victim of domestic abuse has been coerced into committing a crime as part of that domestic abuse, it is treated as such. And it is seen as part of the ongoing abuse. It's seen... and then thirdly is something she'll know I have been campaigning on, and this is the person at risk of violence orders. When somebody leaves a domestic abuse situation, they're often leaving with a lot of debt. In order to keep their address hidden from the perpetrator, they must go through a person at risk of violence order. That's not only another re-traumatising court process, it's also an additional £308 they must find every single time they move. Now, this is despite the fact that they may have an active court case, they may even have the perpetrator has been arrested, but they have to go and independently prove that they are a person at risk of violence. This victims bill is all about making sure that victims can get justice, and part of getting justice is being able to leave these abusive situations and being protected while they're doing it. And I think these three suggestions would really help to strengthen the bill and increase victim survivors' confidence in justice.
Dr. Marie Tidball.
Thank you, Madam Deputy Speaker. Imagine a school night with a child being repeatedly asked by his father if he has completed his homework. The child replied in an exasperated tone, yes. His dad came towards him with his fist, ready to punch him. The boy's mum stepped into the space in front of that fist and pushed her son out of its way. The full force of that fist hit her so hard that she was spun round and fell down the stairs, bruising her arms, legs and back. From the top of the stairs, the child's father shouted to his son, "Look what you made me do." The boy's mother left her husband, taking the children with her. Social services were aware that that same father made statements that he was capable of killing. Then imagine a situation where, despite knowing all of this, a family court permitted that father of those two boys 5 hours unsupervised contact per week. Claire Throssell, my constituent, does not need to imagine that nightmare. She and her two sons, Jack and Paul Sykes, lived it. Yet, on a 2-hour contact visit, permitted by that court and allowed to go ahead by Kafkas, Jack and Paul Sykes were locked in the attic by their father, using gasoline. Their dad set multiple fires alight across their home. Paul, aged 9, died at that scene after his elder brother tried to save him. And then Jack, aged just 12, died later in hospital. The father also killed himself in the blaze. Jack and Paul's voices were not heard by social services, by Kafkas, nor by the family court. The only time Jack's voice was heard was when he was held in the fireman's arms as he used the last of his strength to say, "My dad did this, and he did it on purpose." There must be urgent reform of the presumption of contact in law on the basis of evidence, principle, and to ensure children's voices are put at the heart of our family court system. This legal principle means parents should always be given contact with their children, even in circumstances where there is a known domestic abuser. And yet, the harm report, published in 2020 by the Ministry of Justice's expert harm panel, was clear that the presumption should not remain in its present form. The Victims and Courts Bill before us today presents the ideal opportunity to make these changes in the family courts and deliver for the victims of domestic abuse and violence against women and girls. It already ensures the justice system serves victims rather than subjecting them to further trauma on top of what they have already had to suffer. Labour's important mission to halve violence against women and girls in a decade will require a national effort and using every single tool available to target perpetrators and address the root causes of abuse and violence. Now we need to do what the previous Conservative government failed to do and hold family courts to the same standard by taking a child-centred approach and repeal the presumption of contact where a parent is a known domestic abuser. The government must act now to save lives of children for generations to come by ending contact at any cost. So let's not just imagine a world where the voice of children are put at the heart of our family court system, where children like Jack and Paul, are listened to, not ignored. No more towns like mine left to grieve the way my hometown has. Minister, I urge you to make this a reality.
The Honourable Lady must recognise there is a time limit so members can get in. Jazz Atwa.
Thank you very much, Madam Deputy Speaker. Ilford South has been collectively traumatised by sexual violence and domestic abuse. Together, we've mourned the murders of Hashita Brella and Zara Alina. Together, we're horrified at the cases of physical and sexual violence women and girls face every day, many of which go unreported. That's why the Victims and Courts Bill laid bare before us today is so desperately needed. It's a bill that promises to help us bring justice and empower victim survivors. I'd like to begin by thanking all those who made this bill possible, especially the victim survivors whose voices gave it power and made it real, although their work was indispensable. I know that it must never fall on the shoulders of survivors alone to drive policy change. We all must come together to share the burden of fixing the violence that is so deeply embedded in our society. That's why I feel it's so incumbent on me as a male member to engage with this bill to see it through. Sexual violence and domestic abuse are men's issues as much as women's issues. If I may speak candidly, Madam Deputy Speaker, my conversations with survivors and my work as London Council's lead on community safety and violence against women and girls have taught me that victim survivors are often double traumatised. First traumatised by the experience of their abuse, and then re-traumatised by the justice system that is opaque, difficult to navigate and quite frankly not built for them.
And there is a third trauma when the sentence that emanates from the court is unduly lenient. Now, the Attorney General has the power, as he will know, to review unduly lenient sentences, but only 28 days to do so. Will you join me in calling for that length of time to be extended in the name of victims?
Thank you very much. And certainly somebody who stands for justice, I think anything that makes it stronger, I would always stand for that. I welcome this bill as a start to addressing the injustice survivors face and a vital step to achieving our plan to halve violence against women and girls in a decade. Through the updated victim contact scheme and the new victim helpline, this bill simplifies one aspect of the justice system survivors must navigate. This single harmonised scheme means that victim survivors will have a clear route to request information about an offender's release, should they want it, empowering those survivors. Another welcome aspect of the bill is the automatic restriction of parental responsibility for perpetrators of child sexual offences. Sexual violence against children is particularly vile and traumatising for families and survivors alike, with survivors taking an average of 22 years before they feel able to disclose their abuse. This bill will prevent perpetrators from involvement in a child's life, safeguarding children from further trauma and enabling them to start healing. Of course.
Bowden. I thank the Honourable Member for giving way. He's talking about the length of time it can take for victims of sexual violence to get over their trauma and to seek help. Would he agree with me that organisations such as Rape Crisis do absolutely vital work in helping survivors of sexual abuse and rape move past what has happened? And would he agree with me that it would be a fantastic improvement to the Victims Bill if there could be some national government oversight into how much money is put into funding victim services like those?
Thank you. And certainly coming from a local council strapped for cash, I absolutely agree with the emphasis that the Honourable Member is going towards, and I would say this is something that we must look at as we go forward. The bill will prevent perpetrators from involvement in a child's life, safeguarding children from further trauma and enabling them to start healing. This new restriction is shamefully overdue. Our current system isn't built for survivors. It is full of gaps and loopholes for predators. It reflects society's biases and is perilously hard to navigate. Through truly centre survivors, I believe this bill should go further. The automatic restriction of parental responsibility should be extended so that if an individual abuses any child, not just their own, their parental rights should be automatically removed. This would further safeguard children and save families the vast personal and emotional cost of navigating the family court system, ultimately preventing the re-traumatisation of survivors and their families. I welcome the government's actions to begin building a justice system that finally centres survivors rather than treating them like an afterthought. And I hope this bill will empower those who for so long have not been properly protected. But as we know, there is still so much further to go. There remain so many more battles to fight to prevent sexual violence and empower victim survivors. Online, in our schools, in our homes, on our streets. This bill is a desperately needed first step, but it must be the beginning of our campaign to get justice for victim survivors, not the end. Thank you, Madam Deputy Speaker.
Jess Asato.
Thank you, Madam Deputy Speaker. And can I also pay tribute to my honourable friend, the member for Knowsley, and to Cheryl and her family for their fight for justice. Having worked with both adult and child victims of traumatic abuse, I was glad to stand last year on a manifesto that committed to reforming the system to put the needs of victims first and to ensure they get the support they need and deserve. The bill before us today is part of that mission. I'm pleased to see that it strengthens victims' rights, forces offenders to attend sentencing hearings and empowers the Victims Commissioner to do more to stand up for victims and hold public bodies to account where there are failings. Nevertheless, I think there are three areas in which I believe we should go further and faster. Firstly, we know that victims of domestic abuse and sexual violence are faced with a postcode lottery when it comes to accessing specialist support. They are left at the mercy of the various budgetary decisions made by each area's police and crime commissioner, local authority and health bodies. Where specialist domestic... Of course.
Emily Darlington.
Thank you very much to my honourable friend for giving way. Well, what does she say to a police and crime commissioner like the one for Thames Valley that doesn't fund sexual abuse support services in Milton Keynes?
Jess Asato.
I thank my honourable friend for the intervention. I do believe that all police and crime commissioners ought to, but hopefully the Minister can respond to that. It is clearly outrageous that any victim of sexual violence should be left without a service at all. But where specialist domestic abuse services do exist, they are faced with a deeply precarious financial situation, which is severely hampering the ability of victims to access the support they need. Fewer than half of victims and survivors are able to access the community-based support they wanted. Without that support, some victims may be unable to leave domestic abuse perpetrators or may return to them when they find it too difficult to escape their controlling behaviour. And in 2022, only 7% of victims who wanted their perpetrator to receive the support to change their behaviour and stop reoffending were able to get it. Recent research undertaken by the Domestic Abuse Commissioner has found that 27% of services are having to turn away children victims from vital support due to a lack of capacity. That is why I believe this legislation needs to include a statutory duty to commission specialist domestic abuse and sexual violence services based in the community for both adult and child victims. It is a stain on our nation that victims of the most unimaginable trauma do not have a right to support after abuse. A new statutory duty will also allow us to create parity with accommodation-based services that were introduced in the Domestic Abuse Act in 2021, so that community-based services are given the same legislative protection. Secondly, I believe that the parents and carers of victims of serious sexual and violent crimes also require support as third-party victims. This has been a campaign led by Kath Pickles, the CEO of Restitute, an amazing local charity which supports third-party victims. These crimes fracture families and support networks, and those left to care for primary victims often develop their own mental health issues, may even have to give up work. Mothers who must face picking up the pieces after the sexual abuse of their child, or families who have to support domestic abuse victims as they fight for justice. We should look to include them within the scope of support available to victims, because the impact of abuse doesn't just harm the primary victim, but can destroy their family too. Finally, I recognise that we must not risk a very welcome step forward with potential legal challenges, but I believe we ought to look again at the stricter definition for depriving parental responsibility, particularly where it represents a risk to the child. Many will simply not comprehend how the serious sexual abuse of a child is compatible with the right to family life. What about the child's right to live a life free from harm? I hope the government is willing to work with me and others to tighten this aspect and others as I've outlined as this bill progresses throughout the House. Thank you.
Kira Entwistle.
Deputy Speaker, and I declare an interest as a member of the Women and Equalities Committee. Today marks a defining moment, a moment when we finally put victims at the heart of our justice system. For countless people in Bolton, that moment is long overdue. So I'm proud to support this Victims and Courts Bill, proud because it empowers judges to compel offenders to attend their sentencing, so no victim is left speaking into a void. Proud because it finally removes parental rights from child sex offenders, something I cannot believe we are only doing now in 2025. Proud because it gives real power to the Victims Commissioner to demand answers, scrutinise the system and drive change. And proud because this bill will speed up justice and tear down needless barriers, because survivors deserve a system that works for them, not against them. Madam Deputy Speaker, from conversations on doorsteps to constituency surgeries, far too many of my constituents have experienced domestic abuse and coercive control. That's why I've been working with Bolton's frontline organisations like Fortalis and Endeavour, who understand what's at stake and the difference this bill will make. Fortalis provides refuge and support for domestic abuse survivors. Its chief executive, Jill Smallwood, told me they've had over 400 referrals since January alone, and that this bill will finally deliver the change victims need. Jill told me that right now victims are left in the dark about bail conditions or release dates. This bill will change that. It will finally allow victims to be kept informed by enabling them to nominate a trusted professional to receive updates and access information through a dedicated helpline. Endeavour, another local charity, supports high-risk young people, black and minoritized survivors and older victims. Their chief executive, Jill Caldwell, told me of a woman who had to flee her home, job and support network simply because she wasn't told her abuser had been released. This bill would have prevented that. By guaranteeing the victims the right to up-to-date information, we're ending uncertainty and removing the burden on victims to constantly chase, ask, call and email for updates. We're saying you deserve to know, you deserve to be safe, you deserve to be heard and to be reassured at a time of complete uncertainty when you have already endured so much. This bill is ambitious, but my constituents in Bolton need it to go further. Right now, 82% of domestic abuse victims never report it, not because nothing happened, but because they fear they won't be believed. And for those who do, the courtroom can become a second site of trauma. Time and again, constituents have told me about the misuse of bad character evidence, where a survivor's past is willfully distorted to discredit them. That's not justice, it's re-victimisation. This bill must change evidence standards so no survivor's trauma is ever twisted into testimony against them. This legislation is also a long overdue chance to fix how domestic abuse is handled in the family court system. I would urge the ministerial team to go further and strengthen protections for children of abusers. Survivors in my constituency are still forced into contact with abusers who intentionally exploit the legal process to maintain control. We know that the family court system isn't built to withstand this kind of manipulation, and abusers have learned exactly how to weaponise that and win. The Children and Family Court Advisory Support Service, CAFCAS, rely on outdated, prejudiced views of what a family should look like, prioritising contact with both parents even when one has a proven history of domestic abuse. This antiquated policy prioritises the family unit over the child's best interests, even when the cost is their trust, their stability and their well-being. So this bill must go further. Finally, this bill can end quiet injustice, punishing women simply for surviving abuse. I'm proud that this Labour government is putting power back in the hands of victims, and I fully support this bill.
Vaughan?
Thank you very
very much, Madam Deputy Speaker. Can I firstly pay tribute to the member for Knowsley and also the families of victims across this country who are here listening to us today, and the victims who are seeking justice through this bill, and also my colleague from Bolsover for her strong articulation of concerns around rape and domestic abuse, and my colleague from Penistone, my right honourable friend, for her very strong articulation. There's been some extremely passionate speeches today, and I think they come with their constituents' views at the very heart. As a former police officer, I've seen the criminal justice system from both sides, and I can tell you it has fallen short over recent years, not just in prosecuting crime, but in supporting those that are most harmed by it, and we've heard that testimony today. And this bill is an important and necessary step towards restoring the principle that justice is not just about punishing the offenders, important though that is, but it is standing up for the most important part of it, the victims. And I've said this before in my Westminster Hall debates, that justice delayed is justice denied, and the record of the previous government with regards to cuts to police numbers, to court waiting times soaring, to probation services mismanaged, to our prison services left full, I'm afraid the inheritance is dire, but the government is making a good record of trying to correct that mistake. I'm going to just cover 3 points because I'm cautious that colleagues need to get in. So first of all, on victims' rights, it is absolutely correct that we have reasonable ways of getting the perpetrator into that courtroom. It is true. In my view, it needs to go further, and I would support visual and audio recording of such things. We do this for the Supreme Court, where they're able to see sentencing, and I think with victims' consent, I think justice for high-profile cases should be in the public domain. And I would say, and I would urge the government to go further in allowing the rest of society to see justice being served, and I think we're now reaching that point in our technological development around that. I also believe that victims should have, and I welcome this, a statutory right, not just a courtesy to be kept informed and their voices heard during the critical stages which this bill engages with. I also support the Victims Commissioner. As someone who worked as a police officer, antisocial behaviour is one of the major problems in many communities across the country, from nuisance biking to graffiti to persistent noise, and I believe the Victims Commissioner will have a real power in standing up for those people who are sometimes spoken less in society, and speak up for those towards local councils and other bodies of authority. So I welcome that measure, and I believe those victims of antisocial behaviour should be treated as just the same as any other victim of crime. I also welcome, and I know the Right Honourable Member opposite mentioned sentencing reviews and the time limit with regards to that. So he will be aware, of course, under this bill, we're extending that. So the review, if it's received in the last 14 days of the existing 28-day period, there'll be an additional 14 days to act. Now, could it go further? Of course it could, but this is a welcome step nonetheless. And just lastly, in terms of the court backlogs and the impacts on communities, in my area of Kent, and I've raised this in Westminster Hall, I welcome the powers within the bill to improve sentencing powers for 6 offences, including unlawful subletting, breaches of restraining orders, violation of criminal behaviour orders, so getting the magistrates to step in and work with that. So in short, Madam Deputy Speaker, there's a lot in this bill that we should support, and I encourage colleagues to vote for it today.
Thank you, Madam Deputy Speaker. This government was elected on a promise to deliver a justice system that puts the needs of victims first, and locally in Mansfield, in my constituency, I personally stood to support our police to tackle crime and take back control of our town centre and crack down on antisocial behaviour. And today's bill, alongside other landmark legislation introduced by this government that I voted for in this House, offers further progress to deliver it on this mission for people in Mansfield. And there are 3 parts of the bill that I'd like to highlight that I know will be particularly welcomed back in my constituency. First of all, the strengthening of the powers of the Victims Commissioner. Under previous governments, victims have too often been let down when navigating the criminal justice system, which has made them feel like an afterthought. And it's encouraging to see victims centred in this bill, which has been welcomed by victims' organisations and charities who recognise the potential that this legislation has to make a meaningful difference. And then, secondly, that this bill introduces the ability for judges to hand down sanctions for offenders who refuse to attend hearings. These sanctions including things right from restriction of social visits to longer sentences, and there are of course numerous examples of murderers refusing to attend sentencing hearings, which have led to a need to recognise the need to clarify a court's power to compel attendance. And we know that for some victims, the presence of the offender in court is extremely important for closure and resolution. Yeah. And I welcome that this bill will force criminals to understand and face up to the consequences of their crimes. Absolutely. And then finally, yes, I'll give way.
I'm immensely grateful. At the risk of being repetitive, but will you also press, as I have, and I think his honourable friend there agreed with me, for lenient sentences to be dealt with more severely, by which I mean the Attorney General having extra time to review those sentences, for there is nothing worse for a victim than seeing the perpetrator of the crime given an unduly lenient sentence.
I thank the honourable member for his intervention, and I think he's making a very important and salient point there, so thank you for raising that. And finally, Madam Deputy Speaker, my third point, the bill will place a duty on local authorities and social housing providers to cooperate with the Victims Commissioner in relation to antisocial behaviour. I've spoken many times in Parliament about the need to do more to support the victims of antisocial behaviour in my constituency, and members here will all know, I'm sure, from their casework inbox that antisocial behaviour is not always a criminal justice matter, and that other agencies such as local authorities and social housing providers play an essential part in supporting victims. This bill will therefore empower the Victims Commissioner to get the information needed to identify systemic issues and make informed recommendations, and scrutinise as a whole how the system responds to that type of behaviour, which I wholeheartedly welcome. And in conclusion, Madam Deputy Speaker, I believe that this bill will ensure the criminal justice system serves victims. The previous government allowed the prison system to reach the point of collapse, and as a result, victims were all too often paying the price. And by contrast, Labour is fixing that mess and reforming the social justice system, and I'll therefore be voting today for this landmark piece of legislation, because I know that the measures in it are going to be welcomed back home in my Mansfield constituency.
Thank you, Madam Deputy Speaker. Every day, we as members hear from our constituents that victims of crime have been sidelined, left to navigate a system that often feels indifferent to their suffering. My decision about what to raise in this debate today stemmed from a conversation I had in my constituency surgery a few weeks ago with a constituent who has asked me today to remain anonymous. Madam Deputy Speaker, my constituent told me of an abusive relationship that she was in, a relationship that resulted in the birth of a child. When her child was born, my constituent ended up in court in a custody battle over her child. As part of that trial, she was accused of refusing the father contact. My constituent told me how this horrific experience made her feel. Particularly, she told me that the court system she felt was used as a form of abuse by her former partner. She told me that her claim against him was dismissed as her word against his, and she asked me to look again at parental rights within the context of abusive relationships. In another case, again, a constituent who asked me to remain anonymous, I heard that my constituent was beaten by their partner, who then gained full custody of their child. These are just two of the hundreds of similar stories that I have heard, the thousands of similar stories that my constituents could tell, or indeed the millions of similar stories that women and girls, and indeed men and boys around the country could communicate to us. Well, Madam Deputy Speaker, we are looking at these laws again today. Under the measures introduced in this bill, courts will be used to empower victims. The alleged will be required to attend court hearings, and the Victims Contact Scheme will help victims navigate the legal system with a dedicated helpline. And, Madam Deputy Speaker, automatic parental rights will be restricted in cases of child sexual abuse, exactly as they should be. This bill also includes measures to address antisocial behaviour, an area where I have received lots of representations from my constituents, as I know colleagues across the House will have. At my constituency surgery last Saturday morning, in fact, another individual talked me through the horrific death threats that he had been receiving daily from his neighbour, who spent hours a day screaming through the walls of their semi-detached homes at my constituent and his family. These behaviours left my constituent afraid to leave his home. Under current regulations, ultimately nothing was done, and the behaviours only began to let up when the neighbour ultimately decided to move away of their own volition. This isn't good enough. Madam Deputy Speaker, when the system fails, it is the victims who suffer first and who suffer the most. They deserve better. This bill is a critical part of that better future. So today, let us send a message that the days of delay, denial and degradation are over, and that from now on our justice system will put victims first. Thank you.
Madam Deputy Speaker, it's a privilege to rise in support of the Government's Victims and Courts Bill, and an important and overdue piece of legislation that puts victims where they should always be, at the heart of our criminal justice system. For too long, victims in towns such as Horwich, Westhoughton and Bolton in my constituency have been treated as bystanders, forgotten once the police investigation ends, let down by poor communication and denied a voice in the system that should be shaped to uphold their rights. And with that in mind, I am pleased that this bill will go some way to fixing those issues. Indeed, the bill will give the Victims Commissioner tools to better hold the system to account and stand up for victims, and therefore deliver on this party's manifesto commitment at the general election last year. I would particularly like to welcome remarks made by the Lord Chancellor earlier on new powers for judges to compel offenders to attend their sentencing hearings. Too many families have watched in disbelief as those convicted of the most appalling crimes refuse to face the consequences of their actions in court. And this is about upholding dignity in the courtroom and giving victims the right to see justice done. Crucially, the bill will help tackle the interminable delays and appalling inequality of access to justice left to this Labour government to sort out by the party opposite after 14 years in power. It will do this, importantly, by removing legislative barriers that prevent qualified practitioners from being appointed as Crown prosecutors, thereby making our system more efficient, more flexible and, crucially, more diverse. And it empowers the CPS to recruit from a broader talent pool, ensuring cases are prosecuted more swiftly and reducing unacceptable backlogs. This will ensure the government is finally able to ensure quicker justice in the Magistrates' Court and the Crown Court at Bolton for my constituents. Finally, I'd like to welcome provisions in the bill to close loopholes in the unduly lenient sentence scheme, which have been remarked upon by the Right Honourable Member opposite, ensuring that the Attorney-General will always have at least 14 days to consider a referral, even if it is made at the end of the 28-day limit. This guarantees that victims and the public are not denied proper scrutiny of lenient sentences due to late submissions. This bill is thoughtful, it is robust, and above all, it is victim-focused. I look forward to supporting it during its passage through this place.
Yeah. Now come to the front benches for wind-ups, and I come to the Shadow Minister, Dr. Kieran Mullen.
Madam Deputy Speaker, and I want to begin by thanking members on all sides of the House for their contributions in today's debate. We've heard powerful speeches that reflect the deep importance of this bill and the heavy responsibility we all carry to deliver justice not just in name but in practice. Can I join others in paying tribute to campaigners that I was privileged to meet briefly earlier today and who joined us in the gallery? They're campaigning on behalf of their loved ones, Sabina Nessa, Zara Alina, Jan Mustafa and Olivia Pratt-Corbell. I want to pay particular tribute to the member for Knowsley and her incredibly powerful contribution, and to see Cheryl hear that firsthand, knowing that her words have been put on the record and will have impacted so many members today, I'm sure, will be something that she will never forget. And we must not also forget how difficult their campaigning is. Reliving experiences and memories that are the worst imaginable, they pay a very heavy price every time they do that, and I thank them for it, and I know other members will do the same. The opposition welcome the intent behind this legislation. Measures to compel offenders to attend sentencing hearings and to remove parental responsibility from serious child sex offenders were committed to and begun by the previous government. The provisions to compel offenders to attend their sentencing hearings come as we've seen too many disgraceful examples in recent years where the most serious and violent criminals are hidden from justice and from the pain they've caused. That must end. We welcome cross-party support on this topic. But at present, the bill misses an important principle. The decision to require an offender's attendance should fundamentally be driven by the wishes of the victims and their families. It's they who must live with the consequences of crime, and they who should be at the centre of deciding whether the person who harmed them should be made to face them in court. Justice must not just be seen to be done, it must be shaped by those it seeks to serve. We will work to push for changes to this legislation to ensure that that is the case in future stages. We will also want to make sure that the balances are correctly struck on the use of force. The Prison Officers Association are clear, notwithstanding concerns about their equipment, that in principle they won't reconcile from taking offenders to court. It should only be in the most very exceptional circumstances that it doesn't happen, and the legislation needs to ensure that's the case. We've also seen concerning stories of parents having to spend tens of thousands of pounds in court to remove parental rights from serious sexual offenders, and I welcome the legislation planned under the previous government to begin addressing this. So at this stage, again, we welcome a shared desire to act. But the Minister will have heard already concerns from campaigners that the current approach in this bill doesn't cut it. And I welcome the commitment I saw reported publicly from the Minister that they will consider how we can strengthen it. It was, in fact, the now Home Office Minister, the member for Birmingham Yardley, who I know is joining us in the gallery, that last year supported an amendment for a much broader measure than the government is putting forward today. Given she spoke up strongly for a broader measure when in opposition, I'd encourage the Victims Minister to speak to a colleague, a member of her own government, about how this measure falls short. The debate was around whether it applied to just offenders perpetrating offences against all children and where to set the threshold. Our proposed measure was not perfect, but I have to say I think this measure is the worst of both worlds. Related to only offences against one's own children and quite a high bar of a 4-year sentence, I think we can do better. We also welcome improvements to victims' information rights and the powers of the Victims Commissioner. The role which has been maintained on a cross-party basis for a significant time now is an incredibly important one, and I know Barriss Newlove, the current Commissioner, will look closely at this bill and support victims and campaigners themselves in their efforts to ensure it delivers. And she's also consistently raised a source of funding, which is always a challenge in every government department, in terms of the unpaid victim surcharges, £1 billion plus, that might help fund some of the work we want to do. But whilst there are measures we welcome, there are changes trialled as measures for victims which are nothing of the sort. For example, changes to the unduly lenient sentence scheme, an issue that has caused apparently confusion even in the chamber amongst Labour members who seem to think, I mentioned the member, for example, from Bolton West who's just mentioned it, that these are measures for victims. The measure on the unduly lenient scheme is nothing to do with victims. 14,000 people signed the petition for Sasha's Law, set up by campaigner Katie Brett, who's part of the Justice for Victims group in memory of her sister Sasha. The House will forgive me, but I think it's necessary to detail the nature of what happened to her sister. Katie's sister Sasha was murdered in 2013. Aged just 16, she was raped, stabbed more than 100 times, and her body set on fire. Katie and her family believe her killer met the existing criteria for a whole life order, but he was only given a minimum sentence of 35 years. Katie and her family didn't know anything about the right of appeal, and even if they did, who really thinks most people are in the right state of mind to be thinking about that sort of thing within 28 days of a sentence being passed? Katie isn't alone. Aisha Hussain, another member of the campaign group who was also in the gallery today, campaigns in memory of her cousin Jan. Her killer had raped, tortured and imprisoned various girls and young women, and also murdered Henriette Sucks and hid the bodies of both women in a freezer. He did not receive a whole life sentence and will probably leave prison one day, and again her family knew nothing of the right to appeal. Campaigners reasonably thought, when seeing changes were going to be made to the scheme, that those changes were to give more time beyond the current 28 time limit for victims. But no, the government doesn't want to give victims and families more time, it wants to give itself, the government, more time. More time for government, meaning they have longer than victims to think about and reflect on these deeply personal, sensitive matters, not more time for victims. That is bordering on insulting, and I think the Minister will reflect on and share my concerns about this. In committee, we will put forward, and with the support apparently of Labour members, for example, in Ilford South, who've committed to supporting it today in the Chamber, amendments that require more time for victims, not just the government. And on the issue of victim information, we welcome the creation of a statutory right to information about an offender's release. But again, we ask, how will this be delivered? Who will staff these helplines? And how will victims know their rights? And what exactly will they be told? For some time, the Victims Commission has raised the question of whether victims get to know the release date specifically.
So just to be clear about this, what the current circumstance allows is 28 days for a victim to refer this. And what the bill does is to extend the period for consideration of that to 14 days. What we want is for victims to just have longer. It just seems to me absolutely right that should happen, and a perfectly reasonable amendment which the government could bring to their own legislation to just back victims in that consideration. Is that too much to ask, really?
The member has laid it out exactly correctly, and as I said, I think I count already 3 Labour members who've supported that today in the Chamber, and I look forward to them voting in support of an amendment along those lines, given what they've said today in the Chamber. I might have to not hold my breath. Madam Deputy Speaker, let's be clear, the victims of crime need more than just these measures. They need a criminal justice system that works and that delivers justice swiftly, fairly and consistently, and that is where this bill falls short. In the government, we toughened up sentences for the worst criminals. We began the difficult task of unpicking automatic halfway early release for offenders introduced by Labour. We quadrupled victims' legal aid. We enshrined the Victims Code in law. We dedicated £230 million to our Tackling Domestic Abuse plan, including quadrupling funding for victims and support service. And we introduced tagging of domestic abusers. They made a lot of promises in opposition, including on measures before us today, and it's now up to them to deliver. This bill might tighten certain laws and improve the experience for some victims, but it fails to address the elephant in the room. It does nothing to tackle the fundamental problems that victims face every day when trying to access justice. For all the good it may do, it does nothing to address the mounting pressures on our courts after the government spent a year almost dragging its feet in doing everything it could to get the courts operating at a maximum capacity. Even now, the Secretary of State, the Lord Chancellor, is not pulling every lever available when it comes to court sitting days, as the Lady Chief Justice has repeatedly asked her to do. The truth is, victims are still waiting months, sometimes years, for their cases to be heard. Trials collapse, offenders walk free. None of that is fixed by this bill. Madam Deputy Speaker, being a victim of crime is life-changing. The very least a just society can do is ensure that victims are respected, protected and supported through the process. We also urge the government to commit to greater transparency across the criminal justice system. Without reliable data, we cannot have accountability. Without accountability, we cannot have reform. We will press for regular publication of statistics on court and hearing delays, trial backlogs, court occupancy rates and administrative performance. Victims and the public alike have a right to understand where and why the system is falling short. So while we will not oppose this bill at second reading, we will continue to work constructively to improve this legislation in important ways. We support many of its goals, but will also continue to ask the difficult questions. Is it deliverable? Is it enforceable? And will it actually make victims' lives better in the way intended? Let us make this legislation a genuine step towards a justice system that works better. Justice cannot be delayed, it cannot be selective. It must be felt tangibly, fairly and swiftly by those who need it most. They deserve nothing less.
We'll come to the Minister. Minister Alex Davies-Jones.
Madam Deputy Speaker, it is a true privilege to deliver the closing speech for the second reading of the Victims and Courts Bill. I would also like to start by paying tribute to the families of Olivia Pratt-Cobell, Jan Mustafa, Zara Alina and Sabina Nessa, most of whom have been in the Chamber today and those who I have had the privilege of getting to know over the past few months. As the debate today has shown, the House agrees that justice is not optional. Criminals should never be allowed to hide away from it. And I am grateful to all of the families for their tireless campaign to bring measures on sentencing hearings forward. These changes are an important step forward for victims and a testament to their courage. Can I pay tribute to my honourable friend, the member for Knowsley, for her very, very powerful words today. Not just her words, but the words of Cheryl Corbell, whose words will stay with me forever and whose words should have been heard by the perpetrator of her daughter's killer. And this bill is a legacy for Olivia and a legacy for all of those who have currently been failed by the justice system. As the Lord Chancellor has already outlined, this bill has victims' experience at its core. As the Victims Minister, it is an honour to meet with victims and survivors every single day in this role, and this bill has been created with them at its heart. I would like to echo the tribute from the Shadow Secretary of State for the Justice for Victims campaign, who I have also had the privilege of meeting. Becky and Glenn Eunice, Susan and Jeremy Everard, Katie Brett, whose story we have also powerfully heard from the Shadow Minister, Paula Hudgell, and Aisha Hussain, who was with us today. All of them have helped change the law, and all of them we owe a huge debt of thanks for that. This bill today will make the justice system, and it is a system, it all needs to work in order for it all to operate effectively, more efficient, so that victims can begin to move on with their lives faster. I sincerely want to thank honourable and right honourable members from across the House for their thoughtful, powerful, sometimes emotional, but mostly constructive way in which they've contributed to the debate today. The support and justice for victims should never be political. And I stand here willing to work with anyone of any stripe, of any colour, to make sure that we bring forward the strongest package available for them. Madam Deputy Speaker, the issues and the inheritance of our justice system have long been discussed in this place already. It is well known to members what a state our justice system was in when we came into office just 10 months ago. But can I state that it is this government that has begun to rebuild the foundations of that justice system? And now today, this bill will be just the beginning of our reform programme for victims. It is not the end. We have the independent review of our criminal courts, led by Sir Brian Leveson, which will lead to a more effective and efficient criminal court system, improving timeliness for victims, witnesses and defendants, without jeopardising the requirement for a fair trial for all involved. And we very imminently await the outcome of David Gauke's review into sentencing, which will address a number of the issues that members in the House have raised today. Now, turning to some of the issues that were raised by honourable and right honourable members today, can I first come to my friend, the honourable member for Eastbourne, the Liberal Democrat spokesperson. Can I say how proud I am to work with him for victims in this place? He has always been constructive and is always seeking to do what is right. And although I cannot give him the commitment today, I know I am meeting him tomorrow morning. And we will hopefully have very imminent news for him on a lot of the work that we've been doing together. And again, can I thank also the member sat next to him, a fellow Liberal Democrat, for all her work she's done on court transcripts and specifically the pilot for Rasso transcript, the sentencing remarks. Having spoken to victims and survivors, I know how vital that is for them. The pilot is due to end next week, and again, we shall very soon be publishing our response to that and where we intend to take that forward. So I look forward to speaking with her further on that soon. Many members in this House spoke about the measures around parental responsibility. Look, can I stress that the government have heard the strength of feeling on this issue regarding parental responsibility. Our focus must be on automatically restricting parental responsibility for offenders who have committed those serious child sexual abuse offences, the most heinous crimes in society. And we are taking that step here today in this bill for those who have committed these offences against a child for whom they personally hold parental responsibility, because we need to protect those for which there is a direct harm. This is, and I would stress and echo the words of the Secretary of State, a novel and untested change to the law. The response from perpetrators is unpredictable, so we have currently chosen to focus on the highest harm cases first, because we do not want to have unintended consequences, and we need to prioritise all vulnerable children who are going through the family courts. However, this is the beginning, as we have said, and we look forward to working constructively across the House on this measure. I will happily give way.
I thank my honourable friend for giving way, and I know that she cares deeply about this. I wonder if, in the course of this bill, the government will look at possible amendments that could see the family courts end the presumption of contact and make sure that we end this kind of cycle of abuse.
Champion for this cause and looking at protecting children going through the family courts, as is my honourable friend, the member for Penistone and Stockbridge, whose contribution today was equally powerful. Again, meeting her constituent Claire Throssell ensuring the story of Jack and Paul will stick with me forever. It is one I think about on a daily basis. This government is committed to ensuring that the family justice system delivers the right outcomes for survivors of domestic abuse and their children. We have heard the concerns loud and clear, not just from this chamber, from outside, on the need to go further here. And a child's welfare must always be the family court's paramount consideration when making decisions about that child's life. I want to say that we have undertaken a review at the Ministry of Justice on presumption of parental involvement. The findings, along with any recommendations, will be published shortly, and I look forward to working with members across the House, including my honourable friends, on this soon. There were a lot of comments across the House regarding the unduly lenient sentencing scheme, welcoming the measures in the bill around extending that time limit for the Attorney-General to effectively look at these cases so they are looked at properly so that justice can be served. Honourable members and right honourable members will know that the Law Commission is undertaking a review into the unduly lenient sentencing scheme as a whole, and I would welcome, I'm sure the Law Commission would welcome feedback from honourable and right honourable members on that, and of course we will look at the findings of the Law Commission's review closely so that we ensure that any recommendations brought forward are carried out effectively.
Who I've always liked, by the way, Madam Deputy Speaker. And will that Law Commission review be in time to amend this bill? That's the key, I think. Yes. Because I take on face value what she said about that. Will it be in time? And if not, how can we handle that?
Yeah. I think it's important to look at any recommendations that the Law Commission does properly and effectively, and of course there will be time. We are in the first year of a 5-year Parliament, and this will not be the only bill that comes forward from the Ministry of Justice. As I've said, the justice system that we inherited from the previous government was in crisis. We are beginning to put that back piece by piece, starting with our prisons, our courts, our victim support, family courts, looking at it as a whole. And of course there will be further legislative vehicles coming forward where this could be reviewed if the recommendations are to be adopted by the Ministry of Justice. Now, Madam Deputy Speaker, I know we are short on time this evening, but I wanted to come back to the member for the Weald of Kent's comments on ICSA and just put on record again, because I think it needs to be said, that this government is absolutely focused on delivering meaningful change for victims impacted by these horrendous crimes. Earlier this year, we published our plan for responding to the independent inquiry into child sexual abuse recommendations through the Crime and Policing Bill that I am also proud to be a government minister on. We are strengthening the law, introducing a mandatory reporting duty to make it an offence to fail to report or to cover up child sexual abuse. We are also legislating in that bill to make grooming a statutory aggravating factor in the sentencing of child sexual offences to ensure that this behaviour is reflected in the sentencing of perpetrators. And we also plan to legislate to remove the 3-year limit for compensation claims and shift the burden of proof from victims to defendants in the civil courts, and amend the law of apologies to encourage employers to apologise to people wronged by their employees. A legislative vehicle is currently being identified for that measure, but I just wanted to stress again that it is this government that is getting on with jobs of delivering for those victims and survivors. We are not delaying, we are actively working, and we are doing so at pace to ensure that justice will be served and support is available. Now, the Honourable Member for Dwyfor Meirionnydd raised the case of Rhiannon Bragg. Again, proudly had the opportunity to meet Rhiannon and discuss her case with her. The victim notification scheme that we are introducing through this bill, strengthening that, opening it up to more victims, ensuring that timely communication is available, is something that victims have told me time and time again is needed, and this will be a testament to that. On her calls for Wales, she knows as a proud Welsh MP, I will always stand up for Wales and for Pontypridd, ensuring that a justice system that covers England and Wales robustly is important and is there, and I am meeting the Welsh Government soon to feedback on her concerns specifically. A number of colleagues mentioned the bad character evidence. They will also be aware that the Law Commission is looking into this, and we will again carefully consider recommendations. Again, Madam Deputy Speaker, I want to stress to the members in this House that I'm willing to work constructively on all of these issues that have been raised today, and this bill that is before us today is one of many legislative vehicles that we will have. But in conclusion, Madam Deputy Speaker, this bill today stands before us as a legacy for the victims and survivors that I have had the honour of meeting in my 10 months in this role. These changes are long overdue. They will strengthen our justice system. They will help deliver the accountability and service victims of crime want and deserve. I urge this House to give them its full support, and I stand ready to work with everyone on that. And I proudly commend this bill to the House.
The question is that the bill be now read a second time. As many as that opinion say aye. Aye. Of the contrary, no. The ayes have it, the ayes have it. Programme motion to be moved formally.
I beg to move.
The question is as on the order paper. As many as that opinion say aye. Aye. Of the contrary, no. The ayes have it, the ayes have it. Money resolution to be moved formally.
I beg to move.
The question is as on the order paper. As many as that opinion say aye.
Aye.
Of the contrary, no. The ayes have it, the ayes have it.